Many high-profile cases will definitely come to you, and they may likely come in company of some juicy, irresistible temptations, especially when they involve mouth-watering financial and business transactions. I'm making it clear to you now that you must flee from such disguised danger. Your reputation and integrity matter much, and it counts enormously in your rise to honor and fame in life. Let me point out unambiguously that in life, gifts and wealth that are not worked for, which are by extension undeserving, are always wrapped in calamity and destruction. Flee from them and keep your heads high above the murky waters of corruption and favoritism, so that you can be conveniently counted among the very best in the Nigerian judiciary. You must, against all odds, conduct your affairs within the ambit of the law and the oath that you has just been administered on you. If you were hitherto 50% under public scrutiny, I can then confidently tell you now that it has automatically risen to 100% by virtue of this appointment. This tempo of public assessment of your conduct and disposition will now assume astronomical proportion. You must equally redouble your effort and dialogue properly with your conscience in order not to fall out of the grace of Almighty God and the Nigerian people. It absolutely takes nothing to join the crowd, but it takes quite a lot to stand alone with good conscience. Several novel business and industrial disputes are occurring in the country virtually on a daily basis that have now inevitably made litigations to go on a steady rise. No court in the land is spared of this. We are constantly on our toes, and the dockets are ever rising in response to the challenges of the time. This underscores the fact that Nigeria ranks among the most litigious countries in the whole world. The onus is on your lordships to fasten your belt and roll up your sleeves to face the challenges head on. You must redouble your pace to catch up with the expectations of the litigants. As judicial officers, you have a defined mandate on earth that you must discharge with unveiled honesty and sincerity. You must give good account of yourselves to justify your appointment. However, if you decide to do the contrary, of course, the sledgehammer will, without hesitation, descend heavily on you. No judicial officer at any level of our courts will be allowed to drag the reputation of the Nigerian judiciary into the mud. We can't come this far to fail. Take heed of this admonition by working rightly towards occupying an enviable space in the annals of the Nigerian judiciary.
All right. Good morning, good afternoon, good evening to every one of you. How you guys doing today? Wow. This is the day that we all have been waiting for. It's good to be back here again. It's good to be back here again. Wow. What a journey. What a journey. Jesus. I don't know what you guys are expecting, though. What are you guys expecting? Good morning, good afternoon, good evening to every one of you, depending on your own region where you're watching us from. I appreciate every one of you right there. I'd like to quickly acknowledge the people that is already here with me. Mother of all, Mommy Diaspora, thank you very much, Mommy, for being there from day one till now with me. I want to let you know that I appreciate you, I love you, and I will always love you. Thank you very much. I appreciate every one of you right there. I would like to quickly thank all my team, Madam Irene's Finest, Martina Obasi's TV, I appreciate you all, Mother Patricia Tagbojumi, and many others that have been with us throughout the journey, even those that left. I want to appreciate every one of you. It hasn't been an easy journey. I want to say thank you very much for your time with us. Those of you that left for a reason I don't know, thank you. Those of you that are still with us, thank you. Remember, you were not doing me a favor. You are trying to rescue yourself out of the situation that you and I find ourselves. Unfortunately, some of you were thinking that you were doing me a favor. Oh, my channel, I want to come out. But unfortunately, some of you left. Till now, you are nowhere to be found. I'm talking about some of you that left with hatred. You left because everybody, it's just like everybody want to, I don't know what to put it on. Okay, just like I have a channel right now. Everybody want to have a channel. Everybody must have a YouTube channel. Or you have a supermarket. Everybody must have a supermarket. If I'm a doctor, patronize me. Right? If you are a dentist, I will also patronize you. Right? If you are a realtor, I'll patronize you. We cannot put all our heads in one basket. But the biggest problem that we have as Nigerians is that everybody is competing with each other. Some people left with anger for a reason I don't know. I'm not a perfect person. I've always offended people on this platform, but I've always begged for forgiveness. For example, my brother is right here with me, Mofire. We don't quarrel so many times here. This man, my Yoruba man, is with me here 24/7. I've said it before, in case you guys are not aware, he sent me more of my informations. But I've attacked him here so many times. Listen, guys, not in this life. You and I are fighting for a better country. We want to have a better Nigeria. It's just like Mr. Peter Obi. We played a video the other day. Somebody came out saying, Peter Obi not recognize me. Peter Obi not. Why do you want Peter Obi to recognize you? He only came out to take the lead, but he's doing it for you and I. It's not compulsory. He must be there to be recognizing everybody. Do you know how many obedience we have? How many can you appreciate? If every individualism want Peter Obi to come out and be recognizing everybody, oh, Mike Akinbare, thank you. Mofire, thank you. Nikki Ogu, thank you. He will be mentioning everybody's name. He will do this forever. We cannot live like that. The hate in us is too much. If we can work on that, because I've said it before, today is the D-Day, right? The government must do the right thing. The judiciary must do the right thing. The government is bad. The judiciary is bad. What about you and I? That's what I'm saying. If we manage to change the government, what about us? Our mindset. How are we going to manage to do that? How do you want us to do that? We must change ourselves as well for us to go far. We hate ourselves so much. Many of us don't want to see anybody grow. I want to thank every one of you that have been there with me. Thank you. I appreciate you all equally. My new subscribers, thank you. My old subscribers, thank you. Those of you that have been with me from day one, thank you. Those of you that left, thank you. Those of you that is here right now, thank you. Today, we will know our fate. I've done my part, but I don't have the power to decide the result today. The power where I get, now I put in ever since. Now you put in. Now all of us put in. But today, now the decision, we don't have the power to change anything. We're just here to listen. Thank you very much, my people. Mother of all, Mommy Diaspora, once again, good morning to you. Mike Akinbare, Nikki Oko, good morning to every one of you. Mofire, thank you very much. God bless you all, my people. Press on the like button and let's do this. Marvis Omano say, Light Moses, God bless you all. Good morning, good morning, good morning. Olabimpe, I can see you right there. Good morning to you. God bless you. I appreciate you. Ebuka, John, Oga, can see you as well. Good morning, good morning. Great minds. Thank you. Good morning. Benita, okay. Thank you. Aaron Smart, thank you. Good morning. More Obuera Tanko. Good morning to you. Good morning to every one of you. Ellen Okiti, I can see you as well. Thank you, my wonderful people. Just press on the like button and let us take it from here. Okay, I have more people here. I Sosa, Osadolo, Bright Strasser, Osagbavo Konrai, Stella Imasevedo. God bless every one of you. Good morning to you. Mary 4 days with us as well. Thank you, thank you, thank you. I can see Lady Eugenia. Thank you very much. I really do appreciate every one of you. I'm not taking anybody for granted. Thank you, Gift Ebosele. Thank you, Tony South. God bless you all. Ima Frankly. Thank you, Peter Mosefe. Now God bless you. Now my wonderful people. Sandra Moses, thank you, June Obaseki, Williams Winner, thank you very much. God bless you all, my wonderful people. Joy Taho, and many others. June Obaseki, thank you, my wonderful people. Thank you. Vitals, thank you very much. Amazing Grace USA, my people. Thank you very much, my wonderful people. Mother Patricia Tabujomi, once again, thank you very much. I appreciate you always. Chuku Noso, my brother, thank you very much. You've done well. Your consistency, I want to say thank you. Thank you, my wonderful people. Ashley Obasoge, thank you very much. Lady Eugenia, once again, and God will bless every one of you who are there owners. Tony Maduke, Madam Helen, thank you very much for being there always. Mercy Ago, thank you very much. Thank you, Tony Amaduke, once again. At Discussion Channel TV, thank you very much. Frank Emmanuel, thank you, my wonderful people. Madam Two Sabi is with us as well. Now, God will bless you. Now, just press on the like button. We are already here. We are here, so let's do this. Frank Emmanuel is with us as well. Good morning to you. Tony South, thank you. Peter Inegbe, thank you. Jonathan Kingsley, Aaron Smart, once again. I can see many more people. Your names are repeating again. Okay, I have Constant with us. Thank you, my people. Joy Osayi, and God will bless you. Now, Joshua Aya, thank you. Okay, let me target the people that is saying good morning then, because many names are repeating. Maybe you guys are commenting on something. Okay, I can have Ibadin. Benjamin, thank you very much. Good morning to you. Air Force Love, can see you. Thank you. Matthew, thank you very much. Kate Peter, thank you. Enoma Nusahari, Temidayo Emmanuel, thank you. Anthony Eze, Rita Satu, thank you very much. Winners, thank you. Kathy Williams, thank you. Enoma Nusahari once more. Ajo for Chris. Now, God will bless all of them, my wonderful people. Raymond, thank you. Obvious Peter, yes. Edwin Jimmy, I can see you. Victoria, Victorian Samuel. Thank you, Gato. Thank you very much. God bless you all, my people. Good morning. Yes, Tonya Tom. I can see you. Ken Eddie, thank you. Victor Smart, thank you. Bonaventure. Una complete you. Kai God. All right. Patience. Idewudia, thank you. God bless you all. Ken Eddie, thank you very much. On the like button now, let's do this. Abraham Philip 13, thank you very much. Ima Ogunsuyi, thank you. Edogan Success, thank you. And many others right there. I heard the try man see I not jump any names. In case I do, it's not retentional, just understand with us. Shola David, thank you very much, my people. Now God will bless you now. In case I not mention your name, I bet make una not verse. Joy Terry just coming in. Good morning, Abraham. Thank you. Now God will bless all of you. All of you. If you can hear my voice, God bless you. Even though you don't like me, God bless you. I love you. The best way to return any evil plans to your enemies is to wish them well. Yes, the best way. If they are planning evil for you, wish them well. So the evil is like I told you guys before. Let me quickly say this. Somebody insulted the hell out of me, on a WhatsApp. He sent me long message. I got to talk and insult me. And in fact, he finished me. I settled down, read them. I can't reply them with love. This guy sent me long audio telling me that, Mr. Najawa, you finished me. And as I insult you, Rich, insult your parents, everything. You tell me, say, make I calm down, say you love me. I can't look up, okay? He said, please forgive me. That is how life should be. Some people can be angry and say some things, but it's not enough for you to retaliate. Take them, finish them. No, calm down first. They might get to realize their mistakes later on. God will bless you now. Today is 6 September, Wednesday, 2023. The 2023 presidential election final judgment is today. It's going to start soon. It's going to be, don't worry, we're going to take it live here. Anywhere they are streaming it live, it's going to be streaming live here as well. That's why we are here. I appreciate every one of you. And God will bless you now. I don't really know what to say. It's been a wonderful journey. I want to thank every one of you that have been encouraging me on air and off air. Even sometimes when I'm tired, some of you encourage me to come out. Thank you. It's not easy. We started this with lots of my team, but some of them, they'll get tired. Some of them left with whatever reason, but it's not easy. It was too repetitive. But thank you to everybody that have been part of this success. Even though you're still with us or you're not with us anymore, thank you. It's not easy. It will be for nothing do I alone. Even me, the level I am today in my life, I cannot, there's no way I would have been here without people. That's why you see, I normally say on my platform that a human being cannot succeed in life without the support of a fellow human being. Try them. Just try them. Do everything by yourself without nobody supporting you. You go fail. Even though we know say human being nice to the attack, but everybody needs each other's to grow. That's why you and I stand with Mr. Peter Obi. Obedient. Peter Obi will pay everybody, for example. If we say maybe, okay, Peter Obi, you don't win now, by God's grace, make you win today. Come pay us. Pay every one of us. Make we send our bank account. He no go fit. Peter Obi will become the poorest person on earth. Right? So everybody needs each other. We started this journey before the word obedient came out. Immediately, Mr. Peter Obi decamped out of PDP. That very day, I was already with Sowore. Sowore came here, spent almost 3 hours with us. I assure him, like Mahmoud Yakubu, I assure him that we will start with him with this platform. Then Peter Obi was still in PDP. So I not talk about him. I was not, to be honest, I was not interested. But I've always liked the man. But immediately move out of PDP. I put my car for reverse. Say, no. Peter Obi or nothing. So we're not happy with me till tomorrow because of that. Although we're not reverse. The same message. He even sent me a message yesterday evening. The same message every time. We're not a quarrel. But he let me know. Say no. I said, let her know, listen. It's not about I love you. It's about how the country will be better. If now my own papa me the support before, and Peter Obi can't come out for PDP can't come, I for still leave my papa say, Daddy, I love you. Anyway, if I look at I still live one way or the other, and I still leave my papa now. I love my dad, but I don't support the party. It's like that. So let's stand for what is right. It's not because, don't do things because the person is from your village. Ethnicism. Tribalism is the biggest problem we have today. Then let's go to nepotism, religionism, traditionalism. Look at Pastor Paul Adefarasi. Where to talk yesterday? Say, everybody just carry the move on. Then you can't enter plane, you don't come up for Nigeria. Make we move on. Although I don't know what is going to happen today. The only thing I'm sure that the decision will be taken today is now up to Nigerians. Because I've not seen any video now that Nigerians are already on the street. The only people where they tell me now say the street of Abuja where they shake everywhere. Now Asari Dokubo and the people. Can you imagine? Asari Dokubo and the Niger Delta people, they say that they are Abuja now. They play bands. They torment everywhere. May I never see my fellow Nigerians. Where are you? What is happening? I don't know. To be honest, I've done my part. That's all. I've done my part. Many of you watching me right now, you've done your parts. I don't know what will happen after the decision, and I don't know the decision that's going to be coming out. I just leave everything for God because I've done my part. The only way, my belief is that the only way I believe prayers can work is after you yourself have done your part. You cannot lay in your bed and be telling God you want to be a millionaire, you want to be successful, and you do under your duvet, they press remote. No, you will never be successful, my brother, my sister, you never. So we have done our part. So for me, what I can do, let me don't do so. Yes. Let's see what happened today. Now God bless all of you. We are going to recap on the reactions of some of our people, our fellow Nigerians, obedient last night on Twitter. But before that, I'll post out a link for anybody that want to join this space today. Just join us right now and let's do this. Everywhere is already piling up. Everywhere. Let me post out a link. Although, unfortunately, I did prepare the link. I'm just going to post it like that. I don't write anything because of time. But click on it. Join us right here. I don't send that if you are coming, though. Let's talk about this together. Let's take it together. Today is the judgment. God, when I they grow come, I they hear that word, judgment day. Because there's this movie that I watched, Terminator 2. Now don't watch them, right? Terminator 2, Judgment Day. God. Arnold Schwarzenegger. That's what I actually did my dissertation on in university. Yes, I don't have talking before. I did my dissertation, 30,000 words of essay, but it is called dissertation. On Arnold Schwarzenegger, the actor that acted Judgment Day, that is Terminator 2. Now I write my dissertation on. So for me, there are some words we always use. God go punish you. You don't know what it means. People they talk until you see say God really in your presence punish person where they do bad tele. People they say that word not true, because some words we use it as a chorus because other people are using it. Not that we don't know the meaning, but we don't really know the in-depth meaning. So Judgment Day today can't really be the proper definition of Judgment Day to me. Thank you very much. Give us a bad day, my brother. You're already here with us. Thank you. God bless you. All right, we have Mr. Felix. I don't see you already. Zizo B, thank you very much, but I never see you. Our mandate is sure. Who is there? Oh, Mama. Thank you. I don't see you, Madam Patricia. Thank you, Zizo B. I don't see you as well. God will bless you now. Thank you very much, my wonderful people. Thank you for joining us. Meanwhile, let's quickly recap here and take it from here. Now, God bless you, my people. Press on the like button. Help us to share. I appreciate those of you that just joined us right now. Let's listen to this. Then we start talking. Because according to the information reaching me, that they might start from 10. It's already almost 9:30 right now. We are still patiently waiting for the judgments. Although information also reached me, say, Labour Party, all of them don't reach they don't reach court. But meanwhile, let's listen to this Twitter space here quickly from Violence Space.
Dear Obedience, let me come from a different angle. I want to commend all of you. I want to thank you for making me believe in Nigeria again. I hope with this little movement, I hope with all we have suffered, that with all the history that was banned in Nigeria, we have learned a thing or two about Nigerians and about Nigeria. In this movement in the last 1 year, we were all regular human beings. Nothing concerns some of us with politics. Some of us did not even have PVC. I want to tell you people to remember all we have come through, so that one Justice Samani or one other freak does not start affecting your confidence. I want to remind you that men, they have gaslit the hell out of this movement. They woke up and told us that the candidate who did not engage in anything tribal this election was the tribalist. The candidates who did not deny he was running Muslim ticket, then ended up being Muslim ticket, was not the bigots. Is Obi. I hope that with this movement, you people have seen, if not anything, what Nigeria does to the Igbos. Because I must congratulate all of you for at least supporting Peter Obi. But I hope that this movement showed you how dirty the Nigerian political leader is. I hope you people remember that in this movement, a young boy carried a flag. They beat him up. In this movement, our candidates in Imo State, they burnt him in his car with 5 other people. I want to remind you people in this movement that they have dealt with Peter Obi to the point that Peter Obi came out and told us that if you people, when they froze Take Back Nigeria accounts, Peter Obi told you people that if you know what he is facing, I want to let you imagine how many times they must have used EFCC and DSS on Peter Obi. I just said the man know the open mouth talk. I want to remind you that they killed, before we even started this movement, a woman sat down, gathered some ladies in Jos, and sang a song, Peter Obi will save us. And people came to that woman's house and murdered her in front of her children, Madam Chintex. Make her they remind you. See, Nigerians, we have a terrible memory.
In Kaduna, that's Kaduna.
In Kaduna, pardon. Thanks for the fact check. I just want to remind you. I've asked you people, how many APC people were killed in this election? How many were maimed? How many were brutalized? None. I want to remind you that Igbos exist in 36 states in this country, but no state had an anti-Igbo agenda than Lagos for Bola Ahmed Tinubu. Ogun State did not use anti-Igbo to win. Delta did not fight the Igbos to win. Bola Tinubu started this thing and he has been doing it. I want to remind you in this movement that you did not beg Tinubu to go and traffic heroin. We didn't beg him. Everybody has a choice in life. And we didn't beg him to drop $460,000 with the United States government to solve his drug trafficking and identity fraud problem. You did not beg him, even you that you are in APC, that you are hoping to win this court case by impunity because your candidate, your lawyer, your son brought no evidence to court. Remind yourself that as you went to school as an APC member and as an obedient and as a Nigerian, you did not beg Tinubu not to go to school, primary, secondary. You did not beg him when Habibat Mogaji sent him to Chicago not to take his university serious, considering he didn't take primary and secondary. You didn't beg him. Remind yourself how many times you wrote JAMB. Today, there is a minister that is a youth copper. But Kemi Adeosun was removed from government for forging her NYSC certificate. And you people are telling me that it is after this judiciary, this and that the constitution will die. Abi, it hasn't started dying already. There is a current minister that is a 7 youth copper. Look here, obedience. We have done our best. We supported the best candidates. A man that has no Google Peter Obi fraud, you will see nothing. A man that, as at when he left office and was leaving millions, tens of millions, hundreds of millions of United States dollars, nobody begged him. Nobody begged him to remain money. Nobody begged him. He seemed to use his hand, worked, finished, and left money behind. I want to remind you that in 100 days of Bola Ahmed Tinubu, fuel went from 165 to 720. So that when they are celebrating 100 days in office, And Pastor Saul at the Pharisees is telling you to just forget about it. Forget about it. I want to remind you where you are coming from. So that when you hit the street, it is not because it's Saddam or N6 or anybody that is telling you. Nobody is telling you to hit the streets. You are hitting the streets because it's you as a Nigerian, it is first your right. And then secondly, how can 97 million people register for PVC in the highest PVC registration in Nigerian history? And by the time they suppressed the election, you thugs, you stouts came late on election day, ballot snatched ballot box. To those area boys that are now world famous, that are now an NFT on Okada, snatched ballot box. Everybody snatched ballot box. The election registered 24 million votes. And Mahmoud Yakubu rigged it. He told you that Bola Ahmed Tinubu got 8 million.
All right, guys. Thank you very much. I would like us to continue with channels quickly, um, to see what is happening right there. God bless every one of you. Please help us to press on the like button. Let's
Of
listen to this.
Nigeria in the person of General Muhammadu Buhari, who pursued his mandate in court, not once, not twice, not three times. So you have the raw reports replete with his name. If you share on trial, their lordships will also be conscious. Question is, if they deliver judgment and the outcome is one that they are not comfortable with, what then happens? You go on appeal, you go to the Supreme Court. So the final place for all of this, according to section 285 sub 6, is the appeal court. And also, I think paragraph 55 of the Electoral Act, appeals can be filed at the Supreme Court. So it is for the Supreme Court to now finally determine within 60 days from the filing of the notice of appeal to the filing of the brief to the judgment, everything must be done with. And I think we're trying. It's not there yet, unlike in the past that this particular matter will have taken 4 years, sometimes 5 years. So now it's this, but it can be further compressed. Quoting Mr. Olisa Bakoba, it can be further compressed to 14 days as they've done in Kenya. I think we can do the same here because the rules are clear, the law is clear, the facts are there. So what else are you looking for? Just apply the law to the facts and then deliver your judgment one way or the other.
Well, we are drawing closer and closer to that moment. As you can see on your screen right now, it's now all eyes literally on the seat.
Yes, any other representation?
May it please my lords, Mrs. May Agbamuche Umbu, INEC National Commissioner, Chair Legal Services for the first respondent.
My lords, my name is Kashim Shetima, representing the third respondent. I'm the third respondent.
So, my lord, the second petitioner is represented. The first respondent is also represented here in court. The third respondent is present in court. Other parties are absent. Fourth.
Who is also in court? Second respondent is in court, yes?
My lord,
my name is... Third respondent.
My name is Dr. Abdullahi Umar Ganduje, National Chairman,
okay,
APC, representing the fourth respondent.
Okay.
Fourth respondent.
The fourth respondent is represented here in court, my lord. Other parties are absent. Thank you.
Yes. Well, the list of counsel is they are a bit lengthy. So maybe you can just announce the appearances, but the list is here. We'll record them after the judgment.
My lords, I'm Dr. Levi Uzauku. I appear for the petitioners, my lords.
Yes.
Appearing with me are my brothers of the inner bar, starting with our Kalo SAN, Kichuku Ezechukwu SAN, Dr. Mrs. Valeria Janet Azinge SAN, Becca Okpoko SAN, Alex Ejesiem SAN, Peter Afoba SAN, and then members of the outer bar with us, 3 of them, starting with number 8, Chike A. Obi, Precious Uchendo, and finally, Igwekama Ubiora. Together, we appear for the petitioners, my lords.
You didn't appear with the iron eater today. The iron crusher.
He couldn't be accommodated today.
Okay, Yes, first respondent.
If it pleases my lords, I am Sir Stephen Adehi. I appear with my learned friends of the inner bar, T.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and our friends of the outer bar appearing with us are Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan A. Imrozi, Esquire, Jamiu Aguru, Esquire, and Martins F. Ekpa. We all appear for the first respondent. Thank you very much, my lords.
Second and third respondent.
With profound humility to my noble lords, my name is A.A. Malik. My humble appearance is for the second and third respondents. My learned brothers of the inner bar appearing with me are Babatunde Ogala, SAN, Dr. Remi Olatubura, SAN, and Mutalubi Ojo Adebayo, SAN. And we also have our colleagues on the outer bar, namely my lord, Emmanuel Uwadoka, Esquire, Yinka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Shola, Esquire, and last but not the least, Taiwo Lakanu, Esquire. Grateful, my lords.
Yes.
Good morning, my lords. I am Chief Dr. Charles Uwensi Edosawa. I make a humble appearance for the fourth respondent. With me, sirs, are Chief Adede Akintola, SAN, Chief Afolabi Fashanu, SAN, Sam Ologunrisha, SAN, Solomon Moore, SAN, Abdul Muhammad Rafandadi, SAN. Lords, our learned friends of the outer bar are also here with us. And they're Omosoya Pupola, Esquire, Olarewaju Onigegewura Akinshola, Esquire. Bolaji Oyun, Esquire. Is Huwaila Muhammad Ibrahim. Thank you very much, my lord. We're all here for the fourth respondent.
My people, I don't know what they go through on our mind right now. God. Now wow. I don't know what they go through on our mind. For me, we're about to hear the final judgment. Oh God.
Yes, call number 4.
Petition number CA/PEPC/04/2023 between Allied People's Movement petitioner and Independent National Electoral Commission, All Progressives Congress, Tinubu Bola Ahmed, Kashim Shettima, Kabir Masari.
Please, my lords. Mrs. May Agbamuche Umbu, INEC National Commissioner, Chair Legal Services, for the first respondent.
Petitioner is absent.
Petitioner is absent, my lord. First respondent is represented, my lord.
My lord, my name is Dr. Abdullahi Umar Ganduje, National Chairman, APC, for the first respondent. A second respondent.
My lords, my name is Kashim Shettima. I'm the third respondent.
What?
My lords, I'm the fourth respondent. My name is Kashim Shettima.
My lords, the second respondent is represented. The third respondent is absent. The fourth respondent is present in court, and the fifth respondent is absent.
Yes, appearances, please.
With respect, my lords, my name is Andrew Malgui. My Lord, I appear for the petitioner, and my learned friend of the outer bar, J.O. Olotu, appears with me.
Well, with all this cancellation, please, after this, you submit a clean copy.
Yes, my lord. We had to do some changes in court here, and it was too late for us to adjust.
Okay.
This. Most obliged, my lord.
Thank you. Yes.
May it please my lord, I am Sir Stephen Adehi. I appear with my learned friends of the inner bar, P.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and our friends of the outer bar, of the inner outer bar, Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan Imoesi, Esquire, Jamiu Aguru, Esquire, and Martins F. Ekpa, Esquire. We all appear for the first respondent.
Yes.
Very grateful, my lords.
Yes, second respondent.
May it please your lordships. I'm Chief Dr. Charles Uwensi Edosong. I make a humble appearance for the second respondent. My learned friends, Chief Adeni Akintola, SAN, Chief Afolabi Fasanu, SAN, Sam Ologunrisha, Esquire, SAN, Solomon Umar, Esquire, SAN, Abdul Muhammad Rafindadi, SAN, Omosaya Upola, Esquire, SAN. Sorry, my lord, it's not S. It's my prayer for him, my lord. My prayer for you.
Yeah, that's all right.
That's fine. Olarewaju Akinshola, Esquire. Bolaji Oyun, Esquire. And Miss Huwaila Muhammad Ibrahim. We're all here, sirs, for the second respondent. Thank you, sir.
Yes. Third and fourth.
With profound humility to my noble lords, my name is A. Malik. My humble appearance, my lords, is for the third and fourth respondents. My learned brothers of the inner bar, Obatunde Ogala, SAN, Dr. Remi Olatubura, SAN, and Mutalubi Ojo Adebayo, SAN, all appear with me. Together we have our colleagues appearing with us, namely Emmanuel Uwadoka, Esquire, Yinka Ajeni Fuja, sorry, my lord, Esquire, Akintola Makinde, Esquire, Julius Ishola, Esquire, Taiwo Lakanu, Esquire, and if it pleases my noble lords, may I respectfully add one last name.
We can only record what is on the list.
Sorry, my lord.
Can only record what is on the list.
Most grateful, my lord. My lord, our appearance for the third and fourth respondents. Thank you, my lord.
Most respectfully, my lord.
Yes.
My name is Gabriel M. Isham.
Why didn't you submit your own list? What is here?
Submitted the list.
Yes.
My learned friends who appear with me are Ofure Rosella Iyere. Blessing.
Is it on that name? Is it on the list?
Yes, my lord. It's number 6 on our list.
You mentioned one long name.
O.R. Iyere, my lord.
Okay.
Number 7, P.T. Orabere Esquire. Last but not the least, number 8, Edward Ajaba Esquire. My Lord, collectively, we respectfully appear for the 5th respondent.
Somebody asking why is Peter Obi not there? He doesn't necessarily have to be there. Sorry, he doesn't have to. Today is very tense up, so it's better for him to watch from home. Thank you very much.
That's a security risk for him to be there.
Petition number CA/PEPC/05/2023 between Abubakar Atiku, People's Democratic Party for the petitioners, and Independent National Electoral Commission, INEC, Tinubu Bola Ahmed, and All Progressives Congress, APC.
Yes.
My Lord, my name's Omar Ilya Damagum, Acting National Chairman, PDP, for the second petitioner.
May it please my lords, this is May Agbamuche Umbu, INEC National Commissioner, Chair Legal Services, for the first respondent.
Dr. Abdullahi Umar Ganduje, National Chairman, APC, third respondent.
One petitioner is represented before the court, as well as the first and third respondent, my lord. Other parties are absent.
Please.
With profound respect to my noble lords, I am Chief Chris Uche. I appear for the petitioners, and with me are my learned brothers Silk, namely Iyitayo Jegede SN,
Yes.
Professor Mike Ozekome SN, Nella Andem Ewa Rabana SN. My lords, permit me with respect to replace absent number 5 with my brother Silk Joe Abraham SN. Then number 6, Professor Maxwell M. Gidado SN.
Yes.
7, Chief Godi Uche, SN.
Yes.
8, AK Ajibade, SN. And with us, my lords, our learned friends, Silas Joseph Ono Esquire,
Yes.
and Jude A. Daniel Esquire. Together, my lords, we appear for the petitioners. We are grateful, says.
Yes. Thank you. Second respondent. Oh, sorry, first, sorry.
May it please my lords, I am Sir Stephen Adehi. I appear with my learned friends, senior counsel, T.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and my appearing with us are our learned colleagues, Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan A. Imoisi, Esquire, Jamiu Aguru, Esquire, and Martins F. Ekpa, Esquire. We appear for the first respondent.
Thank you.
May it please, my lords.
Thank you.
With profound humility to my noble lords, my name is A. Malik. I appear, my lord, for the second respondent. Learned Brothers of the Silk, Babatunde Ogala, SAN, Dr. Remi Olatubura, SAN, and Mutalubi Ojo Adebayo, SAN, all appear with me. And we have our other colleagues, Emmanuel Uwadoka, Esquire, Yinka Ajeni Fuja, Esquire, Akintola Makinde, Esquire, Julius Shola, Esquire, and lastly but not the least, Taiwo Lakano, Esquire. Together, my lord, we appear for the second respondent. Grateful, my lord.
My lords, for the third respondent, I am Charles Uwensi Edosawa.
Yes.
My lords, my learned friends, Chief Adeni Akintola, SAN, Chief Afolabi Fashanu, SAN, Sam Ologunrisha, Esquire, SAN, Solomon Umar, Esquire, SAN, Abdul Muhammad Rafindadi, Esquire, SAN, and my learned friends of the Outer Bar, sir, Mr. Omosoya Popola, Mr. Olarewaju Akinshola, Mr. Bolaji Onyu, and Miss Huwaila Muhammad Ibrahim. They're all with me, sirs, for the third respondent. Most grateful, sirs.
On the comment section, I beg make una tell us how they feel right now, my people. What are you expecting? How are you feeling? I just want to see your feelings. Hi, now wow. I've never found myself in this situation before. Jesus.
all this SAM, and all this thing. Yeah, I'm tired of this. This thing, tension is too much, man. Tension is high.
It's just too much, man.
But you even see some of them the way they bow said and they laugh. Like the nation is in a critical situation and they are laughing.
All this criminal SAM.
Consolidated matters. Each of the petitions, though consolidated, will maintain their individual identities, so we shall treat them as such. We shall begin with petition number 4. So we shall begin consideration of this application. So we proceed to the main petition. So in the we all remember that during the judicial session, oral motions were filed. We shall begin with the consideration of this application. So we proceed conducted by the main petition. On the 26th of February 2023. So in this petition, that's petition number 3. Number 4, sorry. Agreed by the declaration. Petitioner, here in Allied People's Movement, participated in the presidential election conducted by the first respondent on the 25th of February 2023 by sponsoring a candidate, petition number 3, Princess. Number 4, sorry. Agreed by the declaration and return at the election. As by today, its petition filed on the 20th day of March 2023, press this court at paragraph 31 of the petition to grant it the following relief. 1. That it may be determined that A, the third respondent was not qualified to contest as the presidential candidate of the second respondent as on 25th day of February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 142, sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended. B, a declaration that the return of the third respondent by the first respondent as the president-elect of the Federal Republic of Nigeria is null, void, and of no legal effect whatsoever. The third respondent having violated the provisions of Section 142, sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the fourth respondent having violated the provision of Section 35 of the Electoral Act 2022. C, the fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. E, the declaration of return of third respondent by the first respondent on 1st March 2023 as the president-elect of the Federal Republic of Nigeria is invalid by reason of non-compliance with the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the Electoral Act 2022. A declaration that having regard to the joint ticket principle enshrined in Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law amounted to automatic withdrawal and invalidation of the candidature of the third respondent as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 25th day of February 2023. A declaration that arising from the invalidity of the third respondent nomination, the first respondent ought not to have included the name or the abbreviation of the name or the logo of the second respondent in the ballot papers and other election materials used by the first respondent for the conduct of the presidential election held on 25th day of February 2023. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the third respondent in the presidential election conducted by the first respondent on 25 February 2023 in view of his non-qualification as a candidate of the second respondent. Upon the ground of prayer 4 above, an order nullifying and/or setting aside the return from declaration of third respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 25th day of February 2023, same having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999 and Section 35 of the Electoral Act 2022. And finally, upon the ground of prayers 5 and 6 above, and in the absence of the third respondent's participation in the presidential election held on 25th February 2023, pursuant to Section 136 sub 2 of the Electoral Act, an order declaring the candidate with the next highest number of votes as the winner of the election. The grounds of the petition as set out in paragraph 15 of the petition is as follows. Your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The respondents were duly served the petition and also responded by filing their replies. The first respondent reply to the petition was filed on 9th of April 2023. The second respondent reply to the petition was also filed on 9th of April 2023, while that of the third and fourth respondents was filed on 13th of April 2023. The fifth respondent also filed replies to the petition on the 16th of April 2023. The petitioner then filed replies to the respective replies of the respondents to the petition. The respondent filed a number of motions, all of which challenge the competence of the petition. These motions were duly heard during the hearing session and ruling reserved. The first motion was filed by the first respondent. Applicant here in this motion was filed on the 6th of May, wherein he sought the following reliefs. 1, an order striking out paragraphs 2, 3, 4, 5, 6, 7, 13, 14, and 15 of the petition reply filed on 20th day of April 2023 in response to the first respondent's reply. 2, an order striking out paragraphs 8, 9, 10, 11, and 12 of the petition reply filed on 20th of April 2023 in response to the first respondent's reply. And for such further orders as the Honorable Tribunal shall deem fit to make in the circumstance. We were urged to note that the grounds for the petition or for the application are as follows. They have been reproduced in the ruling. I need not read them out. So the motion is supported by an affidavit of 4 paragraphs and a written address. The petitioner respondent then responded by filing counter affidavit of 7 paragraphs on 13th of May 2023. Same was accompanied by a written address in opposition to the application. The arguments of counsel in respect of that application have been considered here in the ruling. A similar application was also filed by the second respondent on the 8th of May 2023, wherein the second respondent prayed this court to grant the following reliefs. 1, an order of the Honorable Tribunal granting leave to the second respondent applicant to file and argue this application before or outside the pre-hearing session in this petition. It should be noted that this court is sitting as the Court of Appeal, not as a tribunal. So an order of this Honorable Court striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 17 sub 1, 2, 4, and 5, paragraph 18, 19, 20, 21, 22, 23, and 24 of Part D of the petitioner's reply, and or the entire petition reply to the second respondent's reply to the petition for being an unnecessary repetition and or introduction of new facts unrelated to the second respondent's reply to the petition. 3. An order of the Honorable Court striking out in whole or part thereof of the witness statements on oath filed together with the petition reply to the petition for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2022. The grounds for that application have also been summarized in this judgment, the same thing with the submissions of counsel. The third and fourth respondents also filed a motion on the 13th of May 2023, seeking the following reliefs. 1. An order striking out the entire reply filed by the petitioner on 20th April 2023, together with the accompanying witness statements on oath, list of witnesses to be relied on, and the list of additional documents. 2. Further, or in the alternative to prayer 1 above, an order striking out paragraphs 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, up to 21 of the petition reply under the heading Petition Reply to the third respondent's reply to the motion filed on 20th April 2023 to the applicant's reply to the petition, and for such further orders as this Honorable Court may deem fit to make in the circumstances. The grounds have also been referred to in this ruling. We have also considered the submissions of counsel. Now, it is apparent that the first respondent's motion filed on the 6th of May 2023, the second respondent motion filed on the 8th of April 2023, and the third and fourth respondent motion filed on 13th May 2023 are all aimed at having certain paragraphs of the petition replies to the respective replies of the respondent's replies to the petition struck out. The common ground in all the applications is that the averments in the petitioner's reply have introduced new facts, new issues, facts, and or grounds to the petition. Furthermore, that some of the averments are rehash or repetition of the averments in the petition file, that those averments in the petition replies offend paragraph 16, subparagraph 1A and B of the first schedule to the Electoral Act 2022. The said paragraph to the Electoral Act stipulates that
And baby, will not mute anything for them.
Of his case, which the petition has not dealt with, the petition shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply in answer to the new issue of fact, so that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him, and B, the petitioner reply does not run counter to the provisions of paragraph 14.1. In my view, the provisions of paragraph 16.1 of the first schedule to the Electoral Act 2022 are clear, unequivocal, and unambiguous. It does not, therefore, require any text to be understood. From a holistic reading of that provision, it will be seen that it is meant to explain the purpose of a petitioner's reply to the reply. Is to raise answers to the defense or any fact which must be specifically pleaded and which has the effect of destroying the respondent's defense or make it not maintainable. The bottom line is that a petitioner is permitted by the first schedule to the Electoral Act 2022 to file a reply while the respondent to the petition has in his reply raised new issues of fact in the defense, which fact the petitioner has not dealt with in the petition. However, in doing so, the petitioner reply shall not introduce new facts, grounds, or prayers tending to amend or add to the contents of the petition. I've cited the case of APC and PDP that petitions apply. It is therefore clear that paragraph 16.1 of the first schedule to the Electoral Act does not permit a petitioner in his reply to introduce or bring in any new issue or fact which ought to have been raised in the petition itself. In other words, a petitioner cannot, in the guise of a reply to a respondent's reply, introduce a new issue or fact which was never raised in his petition nor raised by the respondent. To do that will amount to amending or adding to the petition and also taking the respondent by surprise, because at that stage the respondent will not be in a position to react to such new issue or fact. It will therefore breach the respondent's fundamental right to fair hearing. Therefore, the petitioner is not permitted to repair or rehash his averments in the petition in such a way that it will amount to an amendment or restructuring or a reconstruction of the petition. See the case of Dingyadi and Wamako certificates of supply. With the state of the law as stated above, at the back of my mind, I have endeavored to scrutinize the pleadings in the respondent's respective replies to the petition, vis-a-vis the specific paragraphs of the petitioner replies complaint of. I start with the first respondent complaint. The first respondent complaint is against paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 15 of petitioner reply. I have carefully studied those paragraphs of petitioner reply. It is my view that paragraphs 1, 6, 7, 8, 12, and 14 of petitioner reply to the first respondent reply are competent, as they are proper replies to the first respondent's reply. However, paragraphs 2, 3, 4, 5, 9, 10, 11, 13, and 15 of the said petitioner reply are not competent, as they are either rehash of facts pleaded in the petition, or they introduce and or add new facts to the petition. Being incompetent, they are hereby struck out. The complaint of the second respondent is against paragraphs 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, sub 1, 2, 3, and 4 and 5, sorry, 18, 19, 20, 21, 23, 24, and 25, part B of the petition reply to the second respondent's reply to the petition. I've carefully considered those paragraphs in the light of paragraph 16(1)(a) and B of the first schedule to the Electoral Act 2022. It is settled law that where a respondent raises in his reply to the petition fresh or new issues, it will be necessary for the petitioner to file a reply to the respondent reply to the petition. At that stage, the petitioner may also file further written statements on oath of witnesses he may wish to call in rebuttal of the new issues raised by the respondent. This is because any failure by the petitioner to reply or answer to those new issues raised by the respondent will be deemed that the petitioner has conceded to such fresh or new issues. The cases of Idris and ANPP, Dingyadi and Wamako were also cited. That being so, the written statements on oath of witnesses filed along with the petitioner reply to the respondent reply in proof of the paragraph struck out are accordingly struck out. In my view, paragraphs 1, 2, the parallel listed of the petitioner reply to second respondent reply to the petition are either rehash of paragraphs in the petition or introduced or added new facts to the petition. They are incompetent and accordingly struck out. I am also of the view that paragraphs 1, 3, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 to 20 of the petition reply to third and fourth respondent reply to the petition are rehash of the variants in the petition. They are, in my view, incompetent and accordingly struck out. This other motion filed by the first respondent on the 7th of May 2023, seeking the following relief. 1, an order of this honorable court striking out the petition for being incompetent and an abuse of court process. The grounds of filing the motion have been produced. The motion is supported by 6 paragraphs, affidavit deposed to by 1, Give Nwadike, a litigation secretary in the law firm of Dikko and Mahmoud, solicitors to the first respondent applicant. It is also accompanied by a written address filed in support of the motion. In response, the petitioner filed a counter affidavit on the 14th of May 2023, consisting of 7 paragraphs, deposed by 1 Kalu Kenneth Okorie, litigation secretary in the law firm of Mrs. O.M. Atoyo B. SAN and partners. A written address was also filed along with the counter affidavit. I consider the arguments of counsel on this motion. The third and fourth respondents also filed a similar motion on 12th of May 2023. Therein, the third and fourth respondent prayed for an order of this honorable court striking out and or dismissing this petition for being incompetent, fundamentally defective, and vesting no jurisdiction on this honorable court to adjudicate thereon. The grounds for the application have been listed. In this motion, several grounds were raised. Now it is apparent that the sole ground of this petition is stemming on the qualification of the second respondent. The issue of qualification or disqualification of a candidate to contest an election for the office of President of Nigeria is a constitutional one. That is why it is stipulated in section 134, subsection 1A of the Electoral Act 2022 that an election may be questioned on any of the following grounds. A person whose election is questioned was, at the time of the election, not qualified to contest the election. The qualifications and or disqualifications of a candidate to contest an election for the office of president are stipulated in section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended. While the qualifications are inherent in section 131, the disqualifications are ingrained in section 137, subsection 1A to J of the Constitution, supra. It is apparent, therefore, that the issue of qualification of a candidate to contest an election could be a ground in an election petition, though it may also ground a pre-election matter, where such issue of qualification or disqualification of a candidate arises from the primary election of the party by virtue of section 285, subsection 14 of the Constitution. Where the issue of qualification or disqualification arises from before the election, it is an election, a pre-election matter, and an action on that issue must be instituted pursuant to section 285, subsection 11 and 14 of the Constitution. It should be noted that upon a quick and careful perusal of the pleadings and in the petition, the issue of disqualification of the first respondent rests solely on the issue of the alleged invalid nomination of his running mate, with the third respondent. The issue of invalid nomination is captured by paragraphs 18, 19, 20, and 21 of the petition. For proper understanding of the facts pleaded, those paragraphs have been reproduced. The second issue, arm of that issue is captured in paragraphs 22, 23, 24, and 25, and 26 of the petition. Considering the facts pleaded above, it is clear that the claim of disqualification or non-qualification disqualification, non-qualification of the third respondent is centered solely on the invalid or double nomination of the fourth respondent. However, it is the settled law that the issue of nomination of a candidate at an election is a pre-election matter. Therefore, the issue of qualification or disqualification can only be ventilated on the grounds enumerated in sections 131 or 137 of the Constitution. That is why section 84, subsection 3 of the Electoral Act 2022 stipulates that a political party shall not impose nomination qualification or disqualification criteria, measures, or conditions on any aspirant or candidate for any election in its constitution, guidelines, or rules for nomination of candidates for elections, except as prescribed under Section 65, 66, 106, 107, 131, 137, 177, and 185 of the Constitution. 187. It therefore means that the conditions of qualification or disqualification are prescribed by, under Sections 131 and 137 in case of person contesting for office of president. That means that where it is alleged in an election petition that a person is or was not qualified to contest election to the office of President of Nigeria, as stipulated in Section 134, subsection 1A of the Electoral Act 2022, it is Sections 131 and 137 of the Constitution of Nigeria that are applicable. See the cases of PDP and ANIC, Kaki and PDP, Ucha and Unwe, and Captain Idris, Chala Wada and others versus Yahya Bello and others, all citations supplied. That's where election has been conducted and result declared. Such election cannot be questioned on grounds of qualification under Sections 131 and 137 of the Constitution in the case of a presidential election. This postulation is supported by Section 134, subsection 3 of the Electoral Act, where it is stipulated that with respect to subsection 1A, a person is deemed to be qualified for an elective office, and his election shall not be questioned on grounds of qualification if, with respect to the particular election in question, he meets the applicable requirements of Section 65, 106, 137, or 177 of the Constitution, and he is not, as may be applicable in breach of Sections 66, 107, 137, or 182 of the Constitution. As stated earlier, the applicable provisions are Sections 131 and 137 of the Constitution. It is clear from the plenitude of the pleadings in this petition that the facts grounding the petition's claim of disqualification or non-qualification of the third and fourth respondents is hinged on double and invalid nomination of the first respondent. I had pointed out earlier in the course of this ruling that the issue of qualification or disqualification of a candidate at an election is strictly a requirement of the Constitution. That it was held in the case of Al Hassan and another versus Ishaku and others, citation supplied, I quote, by virtue of the provisions of Section 138 sub 1A of the Electoral Act, a tribunal's power to decide whether a person is qualified to contest an election is restricted to establishing the requirements of Section 177 and 182 of the Constitution against the adverse party. An election tribunal has no jurisdiction to inquire into the primaries of a political party, close of court. It is apparent, therefore, that issues of nomination or sponsorship of candidates by political parties come under pre-election matters and should be instituted and determined before the conduct of the election. Shinkafi and others versus Yari and others, Ella and others versus Abo. That being so, a ground of election petition questioning the election of a person duly qualified to contest such election as required by the Constitution cannot be sustained where it is predicated on nomination or sponsorship of such candidate. Therefore, a petitioner who relies on non-qualification of his opponent to nullify the election must bring the facts of such non-qualification within the ambits of Sections 131 and 137 of the 1999 Constitution. I have noted that the petitioner respondent sought to tie his complaint of non-qualification to Section 142(1) of the 1999 Constitution. That provision stipulates as follows. I quote, in any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions of aforesaid. I am of the view that the above cited provision of the Constitution does not create additional qualifications or disqualifications for a candidate contesting for the office of President of Nigeria. Furthermore, Section 142 of the 1919 Constitution, read along with Section 141 of the said Constitution, create the office of President and Vice President. Section 142(1) is a specific provision donating power to the President to nominate a person as his associate to occupy the office of the President. That's why subsection 2 of Section 142 mandates that the requirements of qualification and disqualification attaching to the occupier of seat of President also applies to the holder of the office of Vice President. It is therefore my view that Section 142, subsection 1 of the Constitution does not introduce the issue of nomination or sponsorship of Vice President so as to enlarge the scope of qualifications or disqualifications applicable to the seat of President. There cannot therefore be a disqualifying factor of a candidate for the office of President outside those specified in Section 131 and 137 of the Constitution. It can safely be said that those provisions have sufficiently and conclusively covered the field until there is an amendment to the Constitution. See the cases of AG Abia and AG Federation, also PDP and ANIC Supra. As a fallout to my findings above, I hold the firm view that the issue of nomination or sponsorship of the first respondent, being a pre-election matter, ought to have been ventilated by the petitioner before the Federal High Court, as this court has no jurisdiction to delve into the matter. Even if this court has such jurisdiction, the course of action being a pre-election matter is statute barred by virtue of Section 285, Section 9 of the Constitution of the Federal Republic of Nigeria 1999 as amended. Having found as above, it is my view that the two motions filed by the first respondent and third and fourth respondents on 7 May 2023 and 12 May 2023 respectively have no merit. Accordingly, I find that the petition is have merit. Accordingly, I find that the petition is liable to be struck out for being incompetent. By a motion on notice filed on the 8th of May 2023, the second respondent, applicant, sought the following relief. An order of this Honorable Tribunal granting leave to the second respondent applicant to bring and argue this application before, or outside, or during the pre-hearing session. 2, an order of this Honorable Tribunal paragraphs 1 and 2 contained in paragraph 16 of the petition for being incompetent. 3, an order of the Honorable Tribunal striking out paragraphs 17, 18, 19, 20 to the 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process. And order 4, an order of this tribunal striking out reliefs 1 to 7 of the petition for being incongruous, illogical, and ungrantable. And 5, an order of the Honorable Tribunal dismissing or otherwise striking out the petition for want of jurisdiction and on the ground that the petition does not disclose any reasonable course of action. Here's the grounds stated herein. And I've considered the arguments of counsel which I have summarized in this ruling. It will be seen. It will be seen that this application is premised on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent or applicant that the grounds for the petition are as stated in paragraphs 16 of the petition. A careful perusal of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The averments in paragraph 16 as unequivocal caption deal with the facts of the petition. This ground for the objection to the competence of this petition therefore lacks substance and it is accordingly discountenanced. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the petitioner's respondent had earlier instituted an action before the Federal High Court in suit number FHC/ABG/CS/1215/2022 between Allied People's Movement and INEC and 12 others on the same subject matter as in this petition against the first, second, third, and fourth respondents in this petition and others. It was, however, deposed in paragraph 3M of the counter affidavit filed by the petition in opposition to this application that the matter was not determined on the merit by the trial court, who referred the matter to the Court of Appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law, being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of a court process mala fide or in bad faith to the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at the originating summons in suit number FHC-ABG/CS/1275/2022 will show that same was instituted in the Federal High Court, Abuja, on 27th day of July 2022. Being a pre-election matter, it ought to have been determined within 180 days, as required by Section 285, subsection 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also discontinuous. On whether this petition is caught by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in appeal number CS/ABG/CS/08/2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by either party again in the same or subsequent proceedings, except in special circumstances. For issue estoppel to apply, the following conditions must be satisfied. A, the question must have decided, the same question must have been decided in both proceedings. B, the decision which creates the estoppel must be final, and the parties to the judicial decision or their previous to the proceedings in which the estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually in issue in the proceeding. See the cases of Oyekola and others versus Amodu, OSPM Limited versus Nibel Company Nigeria Limited, and Dasuki Retired versus Federal Republic of Nigeria Sanitation Supply. I have studied the case sought to be relied on as estoppel in this case. It is apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standard by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discontinuous. On whether the question is statute barred, I had held in the earlier motion filed by the first respondent on 7th May 2023 and third and fourth respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination or sponsorship of the fourth respondent, is a pre-election matter. That being a pre-election matter, it ought to have been instituted and ventilated by the petitioner before the Federal High Court within 14 days from the date of recurrence of the event or action complained of. That not having been done, the course of action in this petition stands barred by virtue of Section 2859 of the 1992 Constitution of the Federal Republic of Nigeria as amended. On the issue of local standing, I had also held in the previous motions filed on 7/5/23 and 12/5/23 that issues of nomination or sponsorship of candidate by political parties for an election come under pre-election matters. It is settled that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party for an election. Such process of challenging the nomination is sanctioned by Section 84, subsection 14 of the Electoral Act 22 and 285, section 14 of the Constitution. Sishin Kafi and another versus Abdul Aziz Ayari and Al Hassan another and Ishaku. It therefore follows that the course of action in this petition, which is rooted in the nomination or sponsorship of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the fourth respondent by the second respondent. Thus, in People's Democratic Party (PDP) and Independent National Electoral Commission and others, unreported decision of this of the Supreme Court, delivered on 26th day of May 2023 in SC/CV/501/2023. I heard the matter has been reported, but I have not been able to avail myself of the report. Held at the Supreme Court held at page 71 page 31 lines 1 to 16 thereof as follows. Court, the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of INEC. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law has always been that no political party can challenge nomination of the candidate of another political party, no matter how pained or disgruntled a political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position. It must keep mum and remain an onlooker, for it lacks the local standing to challenge such nomination in court. Close of court. It is clear, therefore, that a political party such as the petition is herein only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondents by the second respondent applicant, the petition is incompetent for lack of local standing on the petition to institute the action. It is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, Subsection 1 of the Electoral Act stipulates, I quote, An election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or," it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinued. By another motion filed on the 15th of May, 2023, the fifth respondent, Das Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of this court dismissing this petition in its entirety for want of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders are this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. I've also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This is Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis. As sui generis, and its procedure is strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not registered parties in an election petition. See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondents. That Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition aforesaid. Close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. In other words, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the fifth respondent on this ground has merit. Finally, I order that the name of the fifth respondent is struck out of this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed and served written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein, 4 issues were raised for determination as follows. 1, whether considering the facts of the petition and evidence laid thereon, the petitioner has the locus standi to question the nomination of the first respondent as a ground of challenging the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. 2, whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134, subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court to question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3, if the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 25th February 2023. 4, whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been produced in this judgment, including the issues raised by the petitioner. Now, it is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 25th February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to jointly contest with the third respondent for the presidential election held on 25th February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of third respondent have been pleaded in paragraphs 16.1 and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act, that has been reproduced earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)A that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for determination of the petition, which paragraphs have been reproduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which have also been reproduced. The second respondent also filed a second respondent reply to the petition Also made their own averments in paragraph 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondents, what appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the present election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected the office of vice president if the candidate is for election to the office of president who nominated him as such an associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. Thus, where the words used are clear and unambiguous, a literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. See the cases of Sani and President Federal Republic of Nigeria, Amadi and Ani, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Okuku, Adol, Peterside, and others, the Supreme Court observed that, I quote, the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for the generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as the intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution while constantly bearing in mind the object which such provisions were made to serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution, being the ground norm, is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner in this case has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. The fourth respondent, while still the senatorial candidate of the second respondent for the Borno Central District, allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. Rulings earlier delivered on the motions and preliminary objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 137, 131 and 137 of the 1999 Constitution. In the cases of Balewa and Muazu and Faleke and Anik Tazu versus Yorea, and in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara state. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can qualify him. This authority can apply mutandis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and sponsorship of third and fourth respondent will find accommodation in a pre-election dispute, which the petitioner cannot even pursue, not being a member of the second respondent. This section 84, subsection 14 of the Electoral Act 2022 and 285, 14 of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merit of the petition. As pointed out earlier in the course of this judgment, a complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2023 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that third respondent, as the fourth respondent nomination was invalid for double nomination, which violates section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent, who was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to ANIC as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIC, that first respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents considered that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified INEC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of his intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended that the issue of alleged double nomination of fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitutes estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions are earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was determined by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act but by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of APC, a different political party. That may well be so, but it is clear from the judgment, thus Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. So, Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case. The other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributed judgment contains what is not in the lead judgment will not whittle down binding effect. Thus, in Olu Fairba and others versus Abdurrahim, my Lord Fabi JSC said, of course, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Now, it is apparent that the parties in Exhibit H1, PDP and ANIC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or privy to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contra mundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. See Black's Law Dictionary, 11th edition at page 1008. Demishola versus Bolarinwa, Janati Petrochemical Limited and EFCC. Then Ladi Jobi and others versus Oguntayo and others, Petition Supply. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contradictory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, "There is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice president candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the contrary judgment that, quote, "It is crystal clear that the two exhibits alluded to above, the first respondent did the needful by resigning his position of senatorial candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress." Close quote. My Lord Okoro went on to, after citing section 31 of the Electoral Act 2022, held at page 8 of his contradictory judgment that I quote, "The above provision of the Electoral Act 2022 was duly complied with by the respondent. My well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served him on the second respondent of the withdrawal of nomination of 6 July 2022, fourth respondent was no longer a candidate for the Borno Central District election, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of His Lordship, Ajim JSC. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INEC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2023 general election has been settled to finality. It is a judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, this Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination of fourth respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and normally allows himself to be nominated by more than one political party or more than one constituency. That's to prove that a candidate knowingly allows himself to be so nominated. Both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited, must be proved. The stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ogumi JC, in his contributory judgment, in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the first respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did. And then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the first respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 26 February 2023. There cannot be any other interpretation in the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JC also contributed as follows, quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nominations without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nominations. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. Second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, fourth edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency, as alleged by the petitioner against the first respondent, has not been established. In other words, both the mens rea and actus reus of the Act prohibited by Section 35 of the Electoral Act 2022 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act, Supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. Further to be considered, the question is, are those testimonies cogent and credible to establish the petitioner allegations stated above? PW1's testimony was only on the alleged double nomination of the third respondent and Petition proceeding, which we have already determined above. Even as he stated that he voted in his polling unit during the election, he stated that he did not play any other role in the election beyond exercising his civic responsibility. As for PW2, who said he was a software engineer, he stated that upon his reading of the relevant provisions of the Electoral Act and annual regulations, he is aware that the presiding officer in the polling unit is mandated to electronically transmit or transfer the result of the election direct to the polling to the collation system as prescribed by ANIC, and to also use the beavers to upload a scanned copy of the polling unit result sheet to the ANIC result viewing portal area prescribed by ANIC. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the ANIC servers, including virtual servers hosted on AWS Cloud. On cross-examination with first respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and ANIC guidelines, and that he was not familiar with the applications and operations of the beavers machine. He stated that he did not play any role in the election. Indeed, as admitted by the witness, the statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it, like from EC8S. He said he did not have the documents and forms he used, and that everything was in laptop. Contrary to the speculation of the petitioners that ANIC was not prepared to conduct the promised credible, authentic, and transmitted election, or that it deliberately or mischievously allowed the compromised IT infrastructure to be deployed for the conduct of the presidential election, PW2 confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with security. In his entire evidence, PW2 did not talk about the contents of any result. Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the first respondent. As for PW3, PW5, and PW6, he merely tendered flash drives containing speeches of the ANIC chairman, Mahmoud Yakubu, and ANIC National Commissioner, Christos Okoye, wherein they gave assurances that results of the election will be transmitted to the RF for public viewing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegation of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PCD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the RF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent objection, we have struck out exhibits PCD 1, 2, 3, as well as exhibits PCE 1 to 4, along with the witness statement on oath of PW4, which was not filed along with the petition since the documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on forms EC8S of 39,556 polling units were inaccessible as they contain uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood result was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,553,553 and numbers of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the RF nor the CTCs or Forms EC8S matched the results of the first respondent. He stated that the annex CTCs of Forms EC8S showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the RF portal showed that LP got 260,796 votes, while APC got 268,630 votes. He added that the annex announced result showed that LP got 308,372 votes and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 blood polling units results, which the witness claimed to have downloaded from the RF portal, show that they were not certified by the first respondent. Being secondary evidence of public documents, they are clearly inadmissible. See Section 89E and 90B of the Evidence Act 2011, case of Emeka versus Ipiazu, others. Of note is that PW4 admitted under cross-examination by first respondent that the primary source of the data he used in his investigation is from the RF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public document is to ensure authenticity of public documents. See the cases of Ebwe and Araka and Emmanuel versus Mana. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on RF portal are not the same thing, and that Form EC8A is a paper, while the result on RF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the RF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death nail to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent suppressed the first respondent's cause to 18,088 polling units by deliberately uploading unreadable and blood forms EC8As on the RF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the RF portal is not capable of collecting and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to RF, while the hard copy of Form EC8A is taken to the collection center, which he stated is collected at what local government, state, and national collection centers. He also admitted that since the result in the Form EC8A is taken to the collection centers, the failure to transmit its image in RF or that image transmitted its blood will not change the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, it would have been different. He further admitted that his report, Exhibit PC 1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. This admission by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. In the whole, the evidence of this witness, even if it were to be considered void of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition. A report in Exhibit PCJ 3A, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PW8, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PW8, having admitted that in the course of his commissioned work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of this petition. PW8 had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed when as accreditation and voting took place. The votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the RF at the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the ANEC regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and ANEC regulations guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward, and that on election day he collected the materials with security agents and other ANEC ad hoc presiding officers. He stated that voting went on well until 6:30 p.m. and all voters who were on queue by 2 p.m. duly voted at Unit 004 DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the RF portal after the result of the National Assembly election was uploaded. He stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them to meet the registration area center tech, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PW8 stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well and the results were entered in Form EC8S in the units and were properly announced. And added that the physical copies of the Form EC8S were taken to the Ward Collation Center. Cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding the difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was subpoenaed, produced, and tendered the following documents. A. Correspondence of documents, letters, emails sent by him, sent by or from Independent National Electoral Commission, the National Information Technology Development Agency, requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by ANEC for the conduct of 2023 general election. B, the certificate of clearance approval issued by NIDA to INEC pursuant to any request in A above. C, the report submitted by INEC to NIDA containing certification for the testing review of the IT infrastructure deployed for the conduct of the 2023 general election stated that they don't have any of the documents in their office. Under cross-examination by the second and third respondents, it stated that the NIDA Act does not contain cyber security standards. It also stated under cross-examination by the fourth respondent that their supervisory ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness was no assistance to the petitioners. PW12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party. Second petitioner, he stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay, settled that hearsay evidence inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1, a certified true copy of the judgment of Federal Court Abuja, suit number FHC ABGCS 1454-2022, was tendered through him under cross-examination by the first respondent, and he read out a portion of the judgment of the court, which was to the effect that the first respondent was under no mandatory obligation to electronically transmit or collect results of the election. He also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent by the first respondent. He also stated that his party had agents throughout the federation with over 133,000 votes. When asked by the second and third respondents council to state the scope of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are being uploaded on the IREF. He added that he will not know the unlawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. When cross-examined by the fourth respondent, PW12 said he was not aware that INEC chairman had given a statement that INEC will not transmit results electronically. When confronted by the fourth respondents council, he confirmed that his statement on oath wherein he stated that he will rely on the evidence of forensic experts was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. Clear that PW12 for relied on an expert report that was not in existence at the time he made his statement. Obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at Open Field Ward 04, Ikun local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results as captured in Form PC8A failed except the National Assembly results. That when all efforts failed, he proceeded to the collection center with other ad hoc staff. When cross-examined by First Respondents Council, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result. That when he could not upload the result, he called his supervising officer, who told him to take the result to the Ward Collection Center, which he did. On cross-examination by Second and Third Respondent Council, he confirmed that after recording the result manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. Quote, A petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the legality or unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the votes cast and the subsequent result of the election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial result of the election. Proving an election petition or proof an election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. The petitioner has a difficult, though not impossible task, close of court. See Mohammed and another for Anladi and others. In this petition, where the petitioners have labeled several allegations against the first respondent, such as suppression of votes, lawful reduction and inflation of results, uploading of fictitious results, misrepresentation, manipulation of results, where no election took place, and wrong computation of results, it is evident from the above that the petitioners have not laid any credible evidence to substantiate those allegations. Of the 13 witnesses recalled, only 2 are presiding officers who were present at the polling, who are present at their polling units. Hence, the petitioners have not been able to establish any of those malpractices which they allege. The evidence of the witnesses which the petitioners call as experts to try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results to average by the first respondent. Any of the malpractices which they allege are devoid of any value. The petitioner allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, Learned Counsel for the first respondent contended that to prove overvoting, the direct record of accredited voters and the beavers machines are required alongside the voters register of the affected polling units. He pointed out that the petitioners failed to produce the beavers machines and the voters register. He submitted that the petitioners want this court to rely only on the expert opinion of PW4, which is not credible. He submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Degema, LGA, River State, which was part of his report on overvoting. In exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. He relied on Oetola and INEC at this court to discountenance PW4's evidence of voting. The petitioner's allegation of overvoting is contained in paragraph 72, 76, and 77 of the petition, which have been produced here. In the area ruling of this court, the respondents' various preliminary objections to the competence of the above affirmative petitioners' allegation of overvoting were upheld, and the court had struck out the said paragraphs for being vague, nebulous, and imprecise, having failed to disclose the specific polling units in the state where the overvoting is alleged to have occurred, the number of votes affected, the alleged margin of lead, etc. Indeed, in that ruling, we had observed that the forensic report containing the details of the polling units and other information which the petition said they have incorporated to the pleading by reference were not filed along with the petition as to be part of the pleadings. Proof of their above allegation of voting, however, the petitioners solely relied on the evidence of PW4, the subpoenaed expert witness, as well as the forensic report made by him, which is contained in Exhibit PCD 1, 2, and 3. Exhibit PW4's evidence was basically that from his investigation in Exhibit PCD 1, 2, and 3, he discovered that there was overvoting in 4,407 polling units, which affected 2,317,129 voters who had collected their PVCs. He stated that this also exceeds the margin of lead over of 1,807,206 over the first runner-up. He also stated that from his analysis of River State results, the first respondent announced results which were inconsistent with those uploaded on the RF portal. PW4 also stated that from the Forms EC8As downloaded from the RF portal, there is evidence of manipulations and alterations in favor of APC and against the Labour Party LP. He stated from the results on the RF portal, LP got 208,564 votes, while APC got 118,999 votes in River State, as against 175,071 votes for LP and 231,591 votes for APC. Concluded that when the unlawful votes are deducted, it will amount to 205,110 votes for LP and 84,108 votes for APC. In the ruling on objections to witnesses and documents made in the earlier part of this judgment, the witnesses stated on oath, a witness statement on oath of PW4 was one of those struck out for offending paragraph 45B of the first schedule to electoral 2022, them not having been filed along with the petition. With the statement of PW4 struck out for being incompetent, exhibits PCD 1, 2, and 3, the forensic report tendered by him were also struck out for being inadmissible. As stated earlier, the oral evidence of PW4 contained in his witness statement on oath and his report in exhibit PCD 1, 2, and 3 are the only evidence adduced by the petitioners to establish their allegation of overvoting. With the witness statement on oath of PW4 having been struck out for being incompetent, and the forensic report in exhibits PCD 2, 1, 2, and 3 also struck out for being inadmissible, there was no other evidence to substantiate the petitioner's allegation of overvoting. The petitioners have therefore failed to prove their allegation of overvoting. Issue 3 is also resolved against the petitioners. So based on the Based on all the foregoing, it is evident that the petitioners have failed to establish their allegations of corrupt practices and overvoting. In consequence, issue 3 is also resolved against the petitioners and favor of the respondents. Issue 4 is whether from the evidence adduced by the petitioners, the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. This issue deals with section 134, subsection 2 of the Constitution, the issue of 25% votes, Abuja. Whatever it is. Well, the resolution of this issue basically borders on the interpretation of section 134, subsection 2B of the 1999 Constitution. The appropriate starting point for the resolution of this issue therefore, is to reproduce, for ease of reference, Section 134(2)(a) and B of the Constitution of the Federal Republic of Nigeria, 1999, as amended, the interpretation of which is in contention. It reads thus: a candidate for an election to the office of president shall be deemed to have been duly elected, where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation and the Federal Capital Territory. The contention is as to the interpretation to be accorded to paragraph B of subsection 2 of section 134 quoted above. In particular, the contention is whether or not, by the wordings in that paragraph, a candidate must, in addition to scoring not less than 1/4 of the votes cast in at least 2/3 of the states in the Federation, also score 1/4 of the votes cast in the Federal Capital Territory, Abuja, before he can be deemed to have been duly elected. In other words, whether in determining 2/3 of the states of the Federation in the Federal Capital is to be included and regarded as one of the states of the Federation, or the status is to be regarded as distinct from the other states of the Federation, such that scoring 1/4 of votes in the FCC is a mandatory requirement for a candidate to be deemed duly elected as president. It is pertinent to state that unlike interpretation of statutes, the interpretation of the Constitution has its own guiding principle. We'll look at the principles as stated in Federal Republic of Nigeria versus Ganjua, reported in the Electoral Law Report, where the Supreme Court succinctly reviewed cited cases on interpretation of the Constitution and outlined these principles, guiding principles as follows. A, in interpreting the Constitution, which is the supreme law of the land, mere technical rules of interpretation of statutes will be avoided so as not to defeat the principles of government enshrined therein. Hence, a broader interpretation should be referred unless there is something in the text or in the rest of the Constitution to indicate that a narrower interpretation will best carry out the objects and purpose of the Constitution. B, all sections of the Constitution are to be construed together and not in isolation. C, where the words are clear and unambiguous, a literal interpretation will be applied. Thus, according to words, their plain and grammatical meaning. D, where there is ambiguity in any section, a holistic interpretation would be resorted to in order to arrive at the intention of its framers. E, since the draft person is not known to be extravagant with words or provisions, every section should be construed in such a manner as not to render other sections redundant or superfluous. F, if the words are ambiguous, the lawmaker's intention must be sought first in the Constitution itself, then in the other legislation and contemporary circumstances by resort to the mischief rule. G, the proper approach to the construction of the Constitution should be one of liberalism, and it is improper to construe any of the provisions of the Constitution as to defeat the obvious ends which the Constitution was envisaged to achieve. See the case of Nafiu Rabiu and the state, Bendel State was Attorney General Federation, Buhari Obasanjo, Savannah Bang Ajilo, Abia State was AG Federation. In finding appropriate answer to this issue, are we to observe first that, with all due respect to counsel to the petitioners, their interpretation of Section 134, subsection 2B of the Constitution, founded principally on a fixation that the word "and" appearing between the phrases, it has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states of the Federation. The Federal Capital Territory Abuja is completely fallacious, if not outrightly ludicrous. Even their recourse to the case of Abubakar and Yaradua does not help their argument because so the JSC made it clear that a purposive rule of interpretation will not be appropriate where the intention of the lawmaker is clear, precise, and unequivocal, so much so that a person can say, yes, this is what the lawmaker has in mind. Thus, in the interpretation of the Constitution, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provision. The Global Excellence Communication Limited, Donald Duke, AG Bendel State, AG Federation, Saraki versus FRN, Sky Bank PLC, Yugu, Kelim versus Gwabang. That this is the position is not at all open to doubt. In Bronic Motors Limited versus Wema Bank Limited, Nnamani JC or blessed memory, speaking from the Appellate Court, confirmed it when, after a painstaking analysis of the case on the point, set at pages 30 to 32, that quote, a constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for now, but for generations yet unborn. In construing it, undue regard must not be paid to merely technical rules. Otherwise, the objects of its provisions, as well as the intention of the framers of the Constitution, will be frustrated. As stated in Minister of Home Affairs versus Fisher, the constitutional requirement should not necessarily be construed in a manner according to rules which apply to acts of parliament. Although the manner of interpretation of constitutional instrument should give effect to the language used, recognition should also be given to the character and origins of the instrument. Such an instrument should be treated as sui generis, calling for principle of implication of its own, suitable to its character, without necessary acceptance of all the presumptions that are relevant to legislation of private law. It has also been accepted by all our courts that a broad and liberal interpretation should prevail in interpreting the provisions of our Constitution, although one has constantly to bear in mind the object which such provisions were intended to serve. Udo Udoma, JSC, very aptly stated this in Nafi Rabiu and the State, where the learned justice said, "My lords, it is my view that the approach of this court to the construction of the Constitution should be, and so it has been, one of liberalism, probably a variation of the theme of the general maxim, ut res magis valeat cum tireat. I do not conceive it to be the duty of this court to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction, equally in accordance with the words and sense of such provisions, will serve to enforce, to protect such a clause of court." Some years down the line, in Global Excellence Communications Limited versus Donald Duke, Onogian JSC, later CJ, reiterated the relevant principle of the implementation of the Constitution, which is Lordship saying, among others, at page 19, followed, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the scope and purpose of its provisions. The words of the Constitution are therefore not to be read with stultifying narrowness. Close of court. All these were further followed by this court recently, the Federal Republic of Nigeria versus Muhammadu Maigari Dingyadi, in the following ways at page 33 of the court. One main guiding post is that the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provisions. See Global Excellence Communication, other cases. There is always a need for the fulfillment of the object and true intent of the Constitution. Therefore, the Constitution must always be construed in such a way that it protects what it sets out to protect and guide what it's meant to guide. The Adeleke or your State House of Assembly. In interpreting the Constitution of a nation, it is the duty of the court to ensure the words of the Constitution preserve the intent of the Constitution. Every Constitution has life and moving spirit within it, and it is this spirit that forms the raison d'etre of the Constitution, without which the Constitution will be a dead piece of document. The life and moving spirit of the Constitution of this country is captured in the preamble. It has been held that when a constitutional provision is interpreted, the cardinal principle is to look to the preamble to the Constitution as guiding star, and the directive principles of state policy as the book of interpretation, and that while the preamble embodies the hopes and aspirations of the people, the direct principles set out the proximate grounds in the governance of the country. The Courtroom and Union of India. In other words, in interpreting the words of Section 212(1)A of the 1999 Constitution as amended, the court should be guided by principles upon which the Constitution was established, rather than by direct operation or literal meaning of the words used in the provision. And where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned to another approach that accords with the guiding principles of the Constitution. The interpretation that would serve the interests of the Constitution and best carry out its objects, purpose must always be part, close of court. Following these well-settled principles, our first port of call in unlocking the argument of the petitioners is the preamble to the 1999 Constitution and the direct principles of state policy contained therein, all of which embody the principles of the Constitution. The preamble to the 1999 Constitution loudly proclaims equality between citizens as its cornerstone, among others. Thus, we, the people of the Federal Republic of Nigeria, having firmly and solemnly resolved and to provide a concession for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people. Do hereby make and give to ourselves the following Constitution. For those who are not used to reading preambles, the Constitution, still in its fundamental objectives and directive principles of state policy, contained in Chapter 2 of the Constitution, which this court aptly described as the road to construction in Federal Republic of Nigeria, and Dingedi repeats this equality principle. Under its social objectives provision of that chapter in Section 17 thereof, it again proclaims that 1. The state social order is founded on ideals of freedom, equality, and justice. 2. In furtherance of the social order, every citizen shall have equality of rights, obligations, and opportunities before the law. Equality of rights in every citizen, as stated in this provision, cannot by any means be read to exclude equality of the weight and value of their votes. No, it includes it. Even more so, when the issue here is the right of every such citizen to elect with their votes their president, whose policies are supposed to and will affect all of them equally, regardless of which part of the country they reside or live. So even stopping here, the futility and hollowness in the argument of the petitioners that the votes of the voters in the FCT, Abuja, have more weight than other voters in the country, to the extent of their votes purportedly have a veto effect on other votes, is rendered bare. That notwithstanding, let us still proceed to consider, for whatever it is worth, their interpretation of Section 134, subsection 2B of the same 1999 Constitution, which incidentally centers around the word "and," that provision. In the first place, the settled position of the law is that in interpreting a constitutional provision of the court should be guided by the principles upon which the Constitution was established, rather than by the direct operation or literal meaning of the words used in the provision. And where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned for another approach that accords with the guiding principles of the Constitution. It is quite clear that a calm reading of Section 134(2)B of the Constitution will leave no one in doubt that the use of the word "and" by the framework between the words all states in the Federation and the Federal Capital Territory Abuja indicates nothing more than that the framers' understandable desire for consistency in referring to the Federal Capital Territory by that name, as it is done all through the Constitution whenever reference is made to the Federal Capital Territory. The word and Federal Capital Territory Abuja do not by any means imply the meaning imputed to it by the petitioners. In any event, Section 299 of the Constitution dispels any lingering doubt that may still be existing in anyone's mind by stating that the provisions of this Constitution shall apply to the Federal Capital Territory Abuja as if it were one of the states of the Federation, then ABC. This provision states most unequivocally that the entire provisions of the Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. It is noteworthy that the punctuation mark employed by the framers immediately after the part of that provision ending with Federation, emphasized by me, is a semicolon, whose function is in a sentence is to separate independent clauses of a compound sentence. The Merriam-Webster's online dictionary, which defines semicolon as a punctuation mark used chiefly in a coordinating function between major sentence elements, such as independent clauses of a compound sentence. Wikipedia also explains its use thus. In the English language, a semicolon is most commonly used to link two independent clauses that are closely related in thought, such as when restating the preceding idea with a different expression. The point being made here is that, contrary to the position of the petitioners, by the express provisions of Section 299 above, the provisions of the entire Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. This means that Section 134, Section 2B of the same Constitution, requiring a president candidate to poll at least 1/4 of the votes cast in 2/3 of the states of the Federation in order to be returned elected, means nothing more than that the Federal Capital Territory shall be taken into account in calculating the state 2/3 of states of the Federation. In other words, the FCT is no more than one of the states of the Federation for the purpose of that calculation. Nothing more than that can be implied or inferable from Section 134, subsection 2B of the Constitution. If anything, this position is confirmed in the cases of Bakari and Ogundipe, where it was said by the Apex Court that by virtue of the provision of Section 299 of the Constitution, it is clear that the Federal Capital of Nigeria has the same status of the state. It is as if it is one of the states of the Federation. And in Ibori versus Uboru, where it was confirmed by this court that the Federal Capital Territory Abuja is to be treated like a state by virtue of Section 299 of the Constitution. If the Federal Capital Territory Abuja is to be treated like any other state, then it is not superior to or inferior to any other state in Nigeria. It is also my considered view that if the framers had wanted to make scoring 1/4 of votes cast in the Federal Capital Territory Abuja a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly spread the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. As expressly stated in Section 299 of the Constitution, for the purposes of fulfilling the requirements of Section 134, subsection 2B of the Constitution, for return of a presidential candidate as duly elected, the Federal Capital Territory Abuja is to be treated as one of the states in the calculation of 2/3 of the states of Federation. Thus, that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory Abuja as the second respondent.
Can you imagine?
In conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. In consequence, issue 4 is also resolved against the petitioners and in favor of the respondents. It is right law that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenges that result to rebut that presumption with credible evidence. This settles principle was stated by the Supreme Court in Buhari and Anik, and Nyesom and Peter cite others. Also in Udom Gabriel Emmanuel versus Umana Okon Umana and others. Both citations applied. I have also referred to Abubakar and Eradua, Louis versus Anik, Kiriko Duluma Hop versus Barrister Joseph Ela and others. From the foregoing, it is clearly evident that the petitioners have failed to discharge the burden of proof placed on them by law. They have failed to prove any of the three grounds contained in paragraph 20 of this petition. They have not been able to lead any cogent, credible, and acceptable evidence to rebut the legal presumption of correctness of the result of the presidential election held on 25th February 2023, led by the first respondent. Having resolved all four issues in this petition against the petitioners, this petition is clearly unmeritorious. As I stated earlier, it's a consolidated petition. So when we examine that of petition number 4, our learned brothers state their own position. And number 5, sorry.
My Lord, sir, I'm very sorry again, sir.
Yes.
Even if your lordships are going to say, your brethren are going to say their piece later on, sir, at least you all, my lord, well, you all should be arrested by saying it is either dismissed or is allowed. Huh? I was wondering if your lordship would not pronounce that it's been dismissed. So that...
what are you saying?
I'm sorry, but I don't want to be confused, sir. I've listened to your lordship's eloquent judgment.
Sorry, please, Leonard Senior. You don't have to interrupt judgment. We are delivering judgment and we are still on. Please leave the judgment where it is.
My lord, I'm very sorry, sir.
If you are confused, when you get the judgment, you read it.
No, my lord, I'm not confused at all.
Okay, then please.
I'm making a suggestion.
You don't imagine how to deliver judgment?
I'm sorry.
So you seriously think that all 5 of us wouldn't know that? Wouldn't know what we want to do?
I apologize.
Oh my God. Oh my God.
I apologize.
Yes. Better we finish. Better we finish. Better we proceed. Better we proceed.
This man will be arrested.
Well, we now proceed on petition number 5. The motions in that petition will be read by my learned brother, by my extreme right.
This is an election petition by the 2 petitioners against the first, second, and third respondents. The first petitioner, Abubakar Atiku, was a candidate at the presidential election held in Nigeria on the 25th day of February 2023. He was sponsored by the second petitioner, People's Democratic Party. The first respondent, INEC, was established as one of the executive bodies created in Section 135 of the Constitution of the Federal Republic of Nigeria, 1999, with power to, among others, organize, undertake, and supervise all elections to the offices of the President and Vice President and others. On Saturday, the 25th of February 2023, the first respondent conducted election to the office of the President and the Vice President for the Federal Republic of Nigeria and the National Assembly simultaneously. Petitioners and the second, third respondents, along with 16 others, participated in the election.
At the conclusion of the election, the first respondent declared the results by which it is indicated as follows. We show the results for out of the two contestants here we are concerned with. The APC of Tinubu Bola Ahmed and Tinubu Bola Ahmed scored were declared to have 8,794,726 votes, and Atiku and the PDP 6,984,520 votes. Petitioners were aggrieved by the outcome of the election, so they filed jointly this petition to challenge this election. The grounds of the petition were four, and these were stated as follows. One, that the election of second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. The election of the second respondent is invalid by reason of corrupt practices. The second respondent was not duly elected by a majority of lawful votes. The second respondent was at the time of the election not qualified to contest the election. The petitioners are seeking the following relief: that it may be determined that second respondent was not duly elected by the majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent as the winner of the presidential election of the 25th of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. That it may be determined that the return of second respondent was by the first respondent was wrongful, unlawful, undue, null and void, having not satisfied the requirements of the Electoral Act and the Constitution of the Federal Republic of Nigeria, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of the states in the Federation, and they put the "and" in capital letters, and the Federal Capital Territory, Abuja. See that it may be determined that the second respondent was at the time of the election not qualified to contest the said election. See that it may be determined that the first petitioner having scored the majority of lawful votes cast at the presidential election of Saturday, 25th February, be returned as the winner of the said election and be sworn in as duly elected president of the Federal Republic of Nigeria. In the alternative, another directing the first respondent to conduct a second election runoff, in brackets, between the first petitioner and second respondent. In the further alternative, that the election to the office of the President of Nigeria held on 25th February be nullified and a fresh election rerun be ordered. G, any such further others as the Honorable Court may deem fit to make in the interest of justice. Upon being served the petition, the respondents joined issues with it by filing the respective replies, incorporating preliminary objections and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. We now proceed to consider them. 7 applications were filed and argued by the respondents during the pre-hearing session of this petition. 2 each of the said applications were filed by the first and second respondents, while 3 were filed by second respondent. First respondents' 2 applications were filed on the 19th of April this year and the 9th of May. The first of his 2 applications dated and filed on the 19th, which also largely reflect the position of second respondent in his first 2 applications and third respondent in his first application. First respondent sought an order striking out paragraphs 92. We gave the paragraphs of the petition on the grounds of their vagueness. Several paragraphs which you get there as you get your the judgment, for being generic, imprecise, and lacking in specificity to elicit a reply from it. B, an order striking out paragraphs 129 and 138 of the petition for failure to join necessary parties. Among other grounds, the 2 necessary parties are Yaya Bello and one Adevo, the chairman of a local government in Kogi State. 3, another striking out the ground of the petition that second respondent did not score majority of lawful votes as contained in paragraph 16C of the petition for incompetence and lacking in specificity and materials in the pleading for a sustenance. Consequent upon 1 to 3 above, another striking out paragraphs A and B and D as sought in paragraph 130 of 150 of the petition, another striking out the ground of the petition that the election is invalid by reason of non-compliance. Consequent upon 5 above, another striking out the ground of the petition alleging that the election of the second respondent is invalid by reason of corrupt practices as contained in paragraph 16B of the petition for lacking specificity and material files in the pleading for a sustenance. 7, another striking out the ground of the petition that the second respondent was at the time of the petition not qualified to contest the election as contained in paragraph 16A of the petition for lacking specificity. 8, another striking out the ground of the petition that the second respondent was at the time of the election not qualified to contest the election. 9, consequent upon 1 to 8 above, another striking out and dismissing the petition for being incompetent. Frivolous, vexatious, abusive. In the alternative to the above, another striking out paragraphs, prayers A, B, C, and D of the petition are sought in paragraph 150 for being incongruous, contradictory, and self-defeatist. The grounds of the petition were stated there, and we set them out, which you get. Second respondent also filed a similar preliminary objection, application for preliminary objection, seeking striking out of the petition or portions of it. A single prayer on the application is an order of the court striking out jointly and or severally paragraphs 14 and 15, 19 to 81, 87 to 104, 108 to 128, and 133 to 150 of the petition for being fundamentally defective. The third respondent on this part in his first application on the same issue filed, we gave the day, sought similar prayers like first and second respondents. All 3 respondents also had issues with the replies petitioner served on them in response to their own replies. Their main complaint this time is that the said replies went beyond the ambit of replies and raised new issues and facts like particulars of the non-qualification of second respondent for the election and his dual citizenship of Republic of Guinea, all of which, according to the reply of the petitioners, impacts on his qualification as a candidate for the election. Those new facts, the complaint tended to amend or reconstruct the petition and so overreach them, even as they do not have any further opportunity to join issues petitioners on them. Other paragraphs of the replies, they said, did not raise new issues, but merely repeated averments already contained in the petition, and so have no place in the reply. For these same reasons, they sought striking out with additional statements, witness statements on oath, and list of documents that accompany the said replies. Besides the above, second respondent had a third application that was peculiar to it. In the said application, which was also filed on the 13th of May 2023, second respondent again sought the striking out of the entire petition, this time on the following 4 grounds. The entire petition constitutes a gross abuse of the process of court by reason of an originating summons in suit number SCCV 354-2023, filed by the Attorneys General of Adamawa, Akwa Ibom, Delta, Edo, and Sokoto states. All of them controlled by the second respondent, as he put them, as he called them, as second respondent put it, at the Supreme Court of Nigeria against the Attorney General of the Federation, where the said plaintiffs raised against the Attorney General of the Federation the same issue here of first respondent's failure to transfer or transmit polling unit results from his BVAS to his result viewing portal IREV in the 25th February 2023 general elections. The plaintiffs wherein first respondent mentioned sought in their suit declarations that the 2023 elections were fundamentally flawed and so invalid, null and of no effect, which is what petitioners also seek here. So this petition constitutes gross abuse of process. There were other grounds for that application, as I shall show later when considering it. All 7 applications were supported with affidavits and written submissions of applicants, which were in turn countered by the petitioners with counter affidavits and written submissions of their own. I shall now proceed to consider the merits of the applications. For ease of reference, I shall group the 3 sets of applications into groups A, B, and C. I start with the first 3 applications of respondents that attacked the validity of the petition and its paragraph reliefs claimed and grounds on which it was sought. First respondent's first application, that is the one filed on 9th of April. I start with that one. First respondent set out the following issues for determination in his 9th April 2023 application. Set them out. It argues its issues 1 and 3, you get it, so there's no point arguing it, time is going. It argues its issues 1 and 2 above separately and took issues 3 and 4 together. In seeking the striking out of paragraphs 9, 2, 3, 93, all set out there, of the petition on grounds of their vagueness, imprecision, and lack of specificity to elicit a reply from it, first respondent, that is INEC, relied principally on paragraph 4.1, sub 1 of the first schedule to the electoral act, which states as follows, says, an election petition under the act shall state clearly the facts of the election petition and the grounds on which petition is based, and the relief sought by the petitioner. Relying on Ugu and Ararume and the number of cases all set out there, counsel on first respondents have argued that paragraph 4.1, the said paragraph 4.1 of the first schedule of the electoral act implies compulsion and makes it mandatory for petitioners to plead the facts of their petition. They submitted that an election petition that is vague, imprecise, omnibus, nebulous, or generic is contrary to the provisions of paragraph 4(1)(d) of the Electoral Act and so liable to be struck out. Let Council then carefully took on each of the said paragraphs and advanced reasons why they are vague, generic as a complaint. Council also argued that the petitioners in paragraphs 129 and 130 of the petition made allegations of unlawful acts allegedly carried out by one Honorable Friday Adejo, Governor Yaya Bello of Kogi State, and some unnamed persons in the course of the presidential election. Yet those persons were not joined to the petition, so those two paragraphs are also liable to be struck out. Council cited Bambe and Adetunji, Olori Ode versus Oyebi, and Babatola and Alade Jono to say the court lacked jurisdiction to enter judgment or make orders against persons that are not before it. Responding to the first limb of first respondent's contention that the said paragraphs of the petition are vague and imprecise, the senior counsel to the petitioners argued that the said paragraphs were pleaded in support of the second ground of the petition, alleging that the presidential election was bedeviled by corrupt practices. Prime among those practices, they said, are suppression of votes, manipulation of beavers' machines, and destruction of electoral materials and ballot boxes. Specific instances of these corrupt practices that took place in various states and local governments, they argued, were laid bare in the petition with particulars of the allegation. They argued that first respondent, instead of considering the paragraphs of the petition holistically, seems to have considered them in isolation and apparently hence its wrong conclusion that the petition was vague, imprecise, and without necessary further particulars. While admitting that the names of polling units were not specifically stated in the petition, Petitioners' Counsel submitted that petitioners stated in different paragraphs of the petition that the polling unit results, polling units affected were to be contained in the statistician's report to be relied upon at the hearing of the petition. They cited the cases of Oluwedu vs. Ajayi, Awolaja and others, as of Citrate and East Horizon Gas Limited versus Afiok and others. To submit that petitioners have by that pleading incorporated by reference the said statistician's reports. On the argument of the first respondent that the petition did not disclose any reasonable cause of action and so constituted abuse of process, Petitioners' Counsel argued that first respondent was by that argument trivializing matters of high constitutional importance raised by petitioners in the petition. Submitted that a petition that touches on correct interpretation of section 133(2)(b) of the Constitution of this country, vis-a-vis the return of second respondent and the qualification or disqualification of second respondent, regulated solely by sections 131 and 137 of the Constitution, cannot by any means said to disclose no reasonable cause of action. On first respondent's contention that petitioners' failure to join Honorable Adejo and Governor Yaya Bello and unnamed thugs against whom they made allegations of criminal misconduct in paragraphs 129 and 133 of their petition made those paragraphs of the petition incompetent and liable to be struck out. Counsel to the petitioner submitted that section 132 of the Electoral Act has specified the persons who may be joined as petitioners or respondents in the election petition. That Honorable Friday Adejo and Governor Yaya Bello, having not participated in the election or returned, petitioners are not in violation of the Electoral Act or any rule of law in not joining them. Besides, they also argued, no relief was claimed against the said two men, so they cannot be said to be affected in any way by the eventual outcome of the petition. Now, this is the way we resolve this. My Lord, resolved it. Now, paragraph 4(1) of the first schedule of the Electoral Act, as amended, states thus: 2020 states thus: an election petition under this act shall state clearly the facts of the petition, and the ground or grounds on which the petition is based and relief sought by the petition. This provision is so clear and direct that it does not require any aid in its interpretation. It simply restates in mandatory terms the first rule of pleading that claimants, in this case a petitioner, shall state clearly, quote and unquote, the facts of the election petition, end quote again, and the ground or grounds on which the petition or claim is brought. This requirement/duty to plead one's complaints and facts clearly in the statement of claim / petition, not reply, is a basic rule of pleading even in ordinary civil proceedings. Emeka Agu in JSC, Natonda versus Ajani, put that point across most forcefully when he said that, and I quote, he said, "It appears to me that rule which required every fact, upon which a party intends to rely at the hearing of the hearing to be pleaded, goes to the fundamentals of justice. For no one and defend the unknown. If one has to defend or counter a fact made by his adversary, the one must have due notice of that fact to enable him prepare for his defense. That is the very essence of pleading. As it goes to the very root of the rule of audi alteram partem, one of the twin pillars of justice, it would be misconception to describe it as mere technicality or regularity. It's a matter which cannot be waived. Indeed, by a long line of decided cases, it has been long settled that any evidence on the fact that ought to have been pleaded but is not, goes to no issue at all at the trial and ought to be disregarded, end quote. Now, the complaint of first respondent is that the petitioners in their petition did not state their case as clearly as required by Section 41D of the Electoral Act, 2002. It complains that petitioners' complaints were vague, imprecise, and lacking in particulars. It does not appear to me that this complaint can by any means be waved away as idle. If anything, even the petitioners seem to have admitted that they did not plead those necessary facts. But their response to that contention, as shown earlier, is that they pleaded a statistician's report, which contains the required details of the polling units where the corrupt practices they alleged took place. Incidentally, the said report, a very voluminous four-part document, the later tendered through his maker, Mr. Samuel Oduton, PW1, during the trial, shows on his face that it did not even exist at the time they filed their petition, and so was not served on respondents along with the petition to enable them exercise their constitutionally guaranteed right of responding fairly to the corrupt practices, quote and unquote, alleged particularized in it, and if necessary, also engage their own expert to reply to it. Engage their own expert to reply to it. Yes, the principle of incorporation, by reference relied on by them, that is petitioners, is part of our adjectival law and is supported by a fairly long line of cases, including MMA versus NMA, Ekpemupolo versus Edremoda and others, DFS Investment versus Brawalai Limited, Elo versus Idaosa, Abode Brothers Limited versus Niger Construction Company Limited and another. But that principle cannot by any means override the fair hearing trial provisions of Section 36 of the 1999 Constitution of this country, which also underpins the rationale for exchange of pleadings by parties. See once again the dictum of Naimeka Agun and Atonda and Ajani already quoted. A statistician's report that is supposed to contain missing particulars in a petition, but which was only filed in the middle of hearing of the same petition, long after the time for exchange of pleadings had closed and even after petitioners had called as many as 16 witnesses in proof of their case, as happened in this case, cannot serve that purpose of Audi alteram partem, let the other party also be heard too. In short, the tactics employed by the petitioners in this case as regards their pleadings, and the petitioners and the statistician's report referred in it, is to say the least most unfair and definitely negates the current practice regime that emphasizes front-loading of processes. Such dishonorable practice can only be likened to the unlawful boxing tactic of hitting one's opponent below the belt or from behind, which in the sport of boxing is penalized promptly with deduction of points. It cannot be different here. The said statistician's report, which is exhibits PAH1, PAH2, PAH3, and PAH4 in this proceeding must be and is hereby discountenanced. That conclusion should make the resolution of this issue of imprecision of the petition fairly easy. I shall nevertheless want to exercise caution and still consider the paragraphs of the petition attacked by first respondent, but it shall only be as they stand in the petition. In that regard, I am satisfied that paragraph 92 of the petition, where the petitioners allege wrongful calculation of polling unit results in various local governments of Sokoto State is lacking in particulars of the particular polling units affected and so liable to be struck out. Paragraphs 93 and 94 of the petition, where petitioners allege that first respondent officials failed to properly fill election forms in Kano State, I think sufficiently meets the requirements of paragraph 41D of the first schedule to the Electoral Act 2022. Paragraph 95 of the petition, where the petitioners allege that results in unspecified polling units in some local government areas of Kogi State were, quote, manipulated through and by the inflation of the second respondent's votes and depletion of the petitioner's votes, end quote, is in my opinion bad for vagueness, not only as to the polling units where the alleged manipulation occurred, but also as to the actual lawful votes of petitioners and second respondents allegedly depleted and inflated respectively. The need to plead the exact figures of votes affected by the alleged manipulation becomes even more crucial, in my opinion, when account is taken of paragraph 15 of the first schedule of the Electoral Act, stating that, and I quote, this is what that paragraph 15 says, when a petitioner claims a seat alleging that he had the highest number of valid votes cast at the election, which is what the petitioners are doing here, the party defending the election or return shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed. Second and third respondents can only properly exercise their right under this provision, requiring them to, quote, give particulars of the votes claimed by the petitioners that they object to and the reasons for the objection against such votes after petitioners have themselves set out clearly the lawful votes depleted by the manipulation alleged by them. Paragraph 97 of the petition, in my opinion, are matters of proof at the hearing, even more so as the petitioners have stated. In those two paragraphs, that the disruption of elections in Adavi and OKE local government areas of Kogi State by agents of second and third respondents, alleged hearing was captured in video recording, which they petitioners would lead evidence in proof. Paragraph 98 of the petition, where petitioners allege that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units. It is therefore also liable to be struck out. I'm also of the opinion that paragraphs 99 and 100 of the petition, also attacked by first respondent, has to do more with proof, which is a matter for the substantive hearing, especially as infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election material, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and what these failures enabled the results of the polling units in the said LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioners' votes is bad and vague as to the particulars of the specific polling units and votes of petitioners and respondents affected by the said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the Electoral Act aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly says so, my lord. We have already produced all these things in CA03, and we don't intend to read. In any case, you get it and you see it. He also PDP versus INEC. For the same reasons, I am also of the opinion that paragraph 103 of the petition, where the petitioner simply avowed generally that, quote, first respondent wrongly entered incorrect results for the petitioners in Borno State, is bad insofar as the polling units in Borno State affected by the incorrect results are not stated. I am, however, of the view that paragraphs 104, 105, and 106 of the petition sufficiently plead necessary for us to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondent of these of beavers machines. The presidential election in Benue State, while paragraphs 105 and 106 simply stated the petitioner's ground that second respondent was not elected by majority of lawful votes. In respect of paragraph 104 of the petition, first respondent complains that the petitioners there contended that the entire results of the presidential election were wrong, yet they did not plead the results they perceived to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4 sub 1 C of the first schedule of the electoral act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone sought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of the Federal Capital Territory, was properly returned by first respondent having regards to the provisions of section 134B of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes. It is therefore in order. I am afraid paragraph 114 of the petition, 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they have that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondent, so I shall overlook it, at least for now. Petitioners in paragraph 121 of the petition allege that first respondents, presiding officers of polling units, failed to properly fill and countersign alterations in election forms, including forms E, C, 8B, and blah, 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 but they did not mention the polling units, what local government and state said infractions took place. They simply reference the same statistician's report. This paragraph is bad for imprecision and so also liable to be struck out. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complained that all over Nigeria, there were manifest cases of overvoting. The total of the affected polling units in the various states are set out in the statistician's report pleaded and relied upon by the petitioners. This pleading is also, end quote, sorry. This pleading is also bad for vagueness. My earlier position on the statistician's report referenced by the petitioners is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondent, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, that paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent against paragraph 129 of the petition, that is also deserves to be struck out for petitioner's failure to join Honorable Adejo, chairman of Oloma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in named polling units in Oloma Boro local government to declare concluded elections in the said units cancelled is well made. The petitioner's response that not only was no relief claimed by them against Honorable Adejo, he did not even participate, quote unquote, in the election, neither was he returned, so it's not a petition contemplated by Section 132 of the Electoral Act to be joined to an election petition. It's not a valid response. Section 133 of the Electoral Act only deals with the issue of which contestant of an election ought to be joined in an election petition by a co-contestant. It has nothing to do with the issue of joining of third parties against whom allegations of electoral infraction are made by practitioners, as in this case. Such petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in Wankwo and Yaradua, where Muntaka Kumasi JSC, after reproducing the provisions of the then newly enacted Section 1441, sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022, and confirming that that provision had done away with the old regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what his lordship said, unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is an issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, his lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the whole petition being struck out. And the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners in the Odo State governorship case of Eitai Ojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State didn't talk to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also bad for non-joinder. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria People's Party scored the majority of lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also bad and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134, sub 4 of the 1999 Constitution, stating expressly that, and I quote, for the purposes of an election to the office of president, the whole of the federation shall be regarded as one constituency, end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the federation or even the federal capital territory only become of consequence when the issue verges on whether the candidate returned also satisfy the provisions of section 131B and 2 of 1999 Constitution, as amended, requiring him to poll 25% of votes cast in at least two-thirds of the 36 states and the federal capital territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. By section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join to his petition, the person returned as the winner of the election. See further on this, the cases of Buhari and another versus Yusuf, Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others, particularly Buhari and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, an unsuccessful candidate in an election cannot be made a party to an election petition against his will, end quote. We also do not agree with first respondent that paragraphs 141, 41, and 142 of the petition were vague or imprecise. I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results. For 22 named states therein, paragraph 44, where they averred that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where these said quote and unquote large scale discrepancies took place. And paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground of their petition that the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said. It's also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings, as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. That paragraph of the petition falls far short of the requirements of paragraph 41B of the first schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahya Bello of Kogi State accused the petition of committing electoral malpractices, paragraphs 92, 95, 98, 11, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 41B. They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140. On the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether having regard to the mandatory provisions of paragraph 41B of the first schedule of the Electoral Act, a reasonable cause of action has been disclosed in respect of grounds of the petition contained in paragraph 16A, B, C, and D of the petition to warrant further or any adjudication on same. Counsel on behalf of first respondent this time anchored the arguments principally on the grounds on which petitioners founded their petition. Counsel reproduced paragraph 16a(b) and C of the petition where the petitioners alleged we set them out. The next reference, section 134 of the electoral act, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1). So the fact that an election shall not be liable to be invalidated by reason of non-compliance with the provisions of the act, if it appears to the election tribunal or court that the election was conducted substantially, in compliance with the principles of the act and in non-compliance with that substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, Senate Council submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the return of second respondent as the winner of the election. That not only the petitioners not assert in their petition that the non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court form an opinion on that non-compliance and corrupt practice complained of substantially affected result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition, the petitioners counsel submitted have simply blown quote unquote muted trumpets and their petition lifeless and failed to disclose a substantial cause of action. So it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners are aware that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election. In that, the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, the first respondent first application. Answer to first respondent, their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition to submit that the petition as by reason of the alleged submission in the petition identified above had become academic and constitute abuse of process of court, so this court is robbed of jurisdiction. Entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issue 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81. For this application, letter counsel second respondent simply said that the sole issue for determination thus was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant electoral act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, and 108 of the petition are not liable to be struck out. We set out the arguments, both of them. He said, in the course of determining first respondent's application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. Same exercise are also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petitioners, paragraphs 92 to 146 of the petition, also made by the second respondent here, I there determined, we said what we listed, and said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 147 to 150, and the few paragraphs between paragraphs 92 to 146 of the petition omitted by the first respondent in the application determined the complaints of second respondent of whether petitioners' complaints in those paragraphs were vague, imprecise, and generic. And now start that exercise. Without reference to what I had said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the amendments in the petition, I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the We did not also find paragraphs 20 to 20 of the petition, where the petitioners complained that first respondent did not keep to his earlier promise of electronic transmission of election results to its IREF portal in real time when it returned this in vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4(1)d and 15 of the first schedule of the Electoral Act 2022, the requirements in paragraph 22 of the petition, where the petitioners complain that the result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their scores. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. We find properly and sufficiently pleaded paragraphs 24 down to 72 of the petition. We, however, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters' cards collected the unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first petitioner and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading ought to contain the precise number of permanent voters' cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in conduct of the election, which practices they complained took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondents' votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by the first respondent for Obi Akpo and Port Harcourt local areas of Rivers State did not reflect the actual votes. If not as press the SL votes, actual votes scored in the said local government areas, or even those updated to IREF by INEC and so liable to be voided, no correct quote unquote figures of the actual votes cast as reflected in the IREF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. Sum total of the foregoing are complaints of vagueness, imprecision, and genericness of environments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 4(1)d of the first schedule of the Electoral Act. Pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondent, who in any case is not under any obligation to help petitioners make out their case against him by asking for particulars of their generic and nebulous complaints. That is also the point that was made by Fabi EJS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for another for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, or devoid of necessary particulars. The decision in Olawekpo versus Saraki, cited by learned counsel on both sides, is in point. It is not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty of second respondent to ask for further particulars, because that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka JSC while delivering lead judgment in PDP versus INEC in 2012, even as the same argument had found favor with his lordship, that is Muntaka, 2 years earlier in his contribution in Nwankwo versus Yaradua. His lordship in the latter case of PDP versus INEC endorsed the stand of trial tribunal in that case, that paragraph 12, sub 5 of the first schedule to the Electoral Act, same as paragraph 12.5 of this present Electoral Act. Okay. Permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act in force at the time Nwankwo and Yaradua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IRF portal in real time, was caught and made comatose by Section 134 of the Electoral Act, stating Electoral Act. We think it is, I think it is neater and even safer to defer it to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again Nwankwo and Yaradua, citation given. Third respondent's application on the same issue of vagueness of paragraphs. Our own application, that is the third respondent this time. In his own application of 8 May, third respondent, like the first and second respondents, also pleaded us to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join Mr. Adejo and Governor Yahaya Bello of Kogi State against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners' amendments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election petition. Again, the petitioners argued in response that their complaints were properly pleaded in the petition and so not imprecise, nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents based on the same paragraph of the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. Further hold that petitioners have amendments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas issues of the assurances given by INEC of real-time transmission of results to IRF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house experts from one department to another before the election as alleged in paragraph 35 of the petition cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners. Sorry, what is there? In petitioners, the amendments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses, testify about first respondents' omissions and commissions in the conduct of election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and third respondents succeed only partly, and the following orders are made on them. Paragraph 23, 82 to 89, 88 to 91, paragraph 95, 95, 98, 121, 124, 126, 129, 133, 135, 136, 143, 144, and 146 are hereby struck out as prayed. The remaining paragraphs of the petition attacks past the vagueness test and paragraph 41D of the first schedule of the Electoral Act 2022 and are hereby upheld. That leaves us with the standalone application of third respondent also filed on 8th of May 2023, as well as the 3 applications of third respondents, all objecting to petitioner's replies to their petition, to their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. We said, then we went on to say that the thrust of the response of petitioner's counsel, that is 455. Thrust of the petitioner's counsel is a suit number SCV 351 that was not filed by the petitioners. So this petition, sorry, I'm still reading 544. And now it is settled position of law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of the action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See your case of Attorney General of Anambra State. Necessarily has to be so because except where a person is shown To be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Alhaji Atiku Abubakar, and his political party, the PDP, can be properly described as previous of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response. For the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound nor obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this. Okay. A good example is recent new currency case. The new currency case that was instituted by the Attorneys General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. In other cases, we cited them, so we go on and on. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case, the said suit number SCCV 354/2023 filed by the plaintiffs in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as Exhibit PV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday Adejo and Yahya and its effect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. Just simply add that we do not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. Proper sanction in circumstances of this case, as we have already pointed out, citing Nwankwo and Yaradua, to strike out the paragraphs of the petition where those allegations were made. That order will also further add, and contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. Obasanjo and Yusuf, where a similar argument was rejected out of hand by Kutigi and Pastor Chalon on JSC. Thus, it was said there that it said, quote, it is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre, end quote. Okay. So the next one, we now go to the challenges, the replies filed with the petitioners. All the respondents also challenge the validity of the replies and their accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies or paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They sought striking out of paragraphs 1.1, 21, 23, and 21 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the petition as Senator Dino Melaye, and PDPC both deposed on 20th April, striking out the petitioner's list of additional documents dated 20th day of April, which accompanied it. Sorry. Thrust of the argument, which is counsel founded principally, and we replied, we reproduced the argument, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relates to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. The second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be had to be objecting to them. The issue raised by first respondent, that is INEC, actually relates to the competence of a major process before the court to which the reply filed by petitioners. It is an issue which counsel to first respondent as ministers in Temple of Justice, and even first respondent itself as a party to the petition, have a duty to bring to the attention of the court. That obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. This preliminary objection, like the argument of petitioners, therefore rejected. Coming now to the merits of the application, it is common ground that the provisions of the electoral act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision, with the employment of the word shall, forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the contents of this petition. Cited cases, I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this thing, only restates the well-settled position of adjective law that a claimant's claim or grievance are made in a statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Ulubodu and Lawal. Cited what the Supreme Court said there. They said a plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad, and no evidence would be admissible in his proof, end quote. In fact, that settled position of law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is in law an implied joinder of issues on any fact raised in the statement of defense, and any averment contained therein is deemed denied. This is cited. And so what will amount to a new issue we cite again against Simba? Against Simba was earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners into their reply. The additional averments of how results could not have been uploaded to INEC's IREV after the 25th of February, and C, whether it was done at all and relevant officials of INEC could not have been involved in it, not to talk of the repetitions reply of averments already made by petitioners in their petition can pass as reply filed pursuant to paragraph 16(1)(a) of the Schedule of the Electoral Act, particularly as relates to the further details as are quote and unquote, as petitioners labeled them in their reply, of non-qualification of second respondent contained in paragraph 2(1)(b) of their reply. It bears reiterating that all that the petitioners refer to in paragraph 146 of their petition is the bare statement that, quote, the petitioners have vowed that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, unquote. No details whatsoever was given by them of what they meant by second respondent's non-qualification. So first respondent, who was obviously satisfied that second respondent was qualified to contest the election by the documents he presented to it, also simply joined issues with them in a similar general manner. It is now through their reply that petitioners, who themselves seemed to have had a clear idea of what they meant by second respondent's non-qualification for the election, or simply deliberately kept it back when filing their petition, want to now introduce through their reply at a time when respondents have no further right of responding to them. Such unfair tactics cannot and is not allowed by our law. It must be noted, too, that under Section 131 of the 1999 Constitution of this country, there are as many as 4 different qualifications the person must possess before he can contest presidential election, and another 10 different grounds that can qualify such a candidate who has all the 4 qualifications of Section 131. Therefore, an assertion that merely says that a person is not qualified to contest election by reason of non-qualification will leave not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61(a) of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 2(1)(b) of their reply that they were simply given, as they put it, further details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they have had in paragraph 1B of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. They are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraphs 2(1)B and C of the reply, where petitioners have had to no uploading of polling units results by first respondent, presiding officer at the election, we also agree with first respondent, are new issues or at least mere further denials by the petitioners, respondent denials of the petition. Such is not also permitted in the reply. See again, Bakar and another, versus Ibrahim, Akeredolu versus Akinremi, Egesimba versus Nuzurike, Spasco versus Alrain, Ishola versus LGB, and Obot versus CBN. In the light of all the foregoing, the two witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply in the issue, are also incompetent and liable to be struck out. In summary, first respondents' applications of 9th May succeeds in its entirety. Accordingly, paragraphs 1, 2, them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2(1)B, 2.1, B, C, and D of the petitioner's reply, filed in response to the reply of first respondent together with two witness statements or note and list of documents which accompany that reply are all hereby struck out. Second respondent's application seeking striking out the self-respondents. Learned counsel also made his arguments, and then we come straight to the resolution. And I said here, my lord said here, that I'm not even in the least persuaded by the argument of the petitioners, that they simply reply to new issues raised by second respondents in reply to their petition. Petitioners, like they did in their reply to the reply of first respondent, introduced fresh facts and issues of non-qualification of second respondent on grounds of his alleged criminal conviction, forgery of documents, and dual citizenship. That is foul play, which paragraph 16 sub 1A to the first schedule of the Electoral Act expressly forbids. Consequently, paragraphs 1B, 1, Roman figure 7, A, B, C, and Roman figure 8 of part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of part 2 of the reply of petitioners. Second respondent, where the petitioners have had new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification, are all hereby struck out. Paragraphs 8, 11, Roman figure 1, 24, and 24B of the petition we hold on the state of the authorities earlier considered are also new facts or at best mere denials and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on the 23rd of reply 2023 stand either not objected to or the complaints against them are not made out. In other words, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, and now we come to third respondent's application, and we come straight to say that I find necessary to first observe that like all other replies of the petitioners, the impugned reply of petitioners of 24 that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent's reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist qualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 15A stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, that last paragraph 35, as third respondents has rightly pointed out, either mere denials of third respondents' reply to the petition or repetitions of petitioners' amendments in their petition, and so not permissible in a reply as per paragraph 16AB, 1A of the first schedule of the Electoral Act. See again, cited cases. It's also not the law, as erroneously argued by petitioners' counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. Somehow, counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. See against Simba's case, Ayola GSC, I cited the summary. Third respondent's application succeeds in its entirety. Consequently, barring paragraph 35, the entire part B of the reply of the petitioner's reply of third respondent is incompetent and is hereby struck out. That concludes and settles all 7 applications trust preliminary objections of respondents. So that is it. So I now hand over to my leader, as politicians we want to call it, so that my Lord can continue from there.
We'll go to the respondent's objections to documents tendered at the trial. My land brought by my immediate right to read the ruling.
Thank you. We want to take on the respondent's objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the three respondents. First, to the validity of the witness statements on oath, proposed to by some of the witnesses of the petition. Specifically, EW 12, that is petitioner's 12th witness, Eguma Friday. EW 13, that is Grace Timothy. EW 14, Grace Ajagbona. EW 15, Abidemi Joseph. EW 16, Ms. Edosa Obasa. EW 17, Ms. Aleri Ayuba. EW 18, Ms. Sadia Mohamed Haruna. EW 21, Mr. Samuel Odunta, the statistician. EW 23, Janet Nuhu Turaki. EW 24, Christopher Bulus Ado. EW 25, Victoria Sani. EW 26, Hitler Egwonu Nwala, the forensic expert. And PW 27, Mr. Mike Enahoro Eba, legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties. The ruling on it deferred by the court to final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. I now proceed to consider the said objections of respondents. 1, the validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45E of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by first respondents' counsel on 8th of June 2023, when PW12, Mr. Eguma Omachono Friday, the presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition, and even after hearing of the petition had commenced, Respondents' Counsel again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanikwekwe SAN, for second respondent, was anchored on paragraph 45B of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned Counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 45B and 6, sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 45B of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondents has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election, and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREV, major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PW 21 Samuel Odunton and PW 26 Hitler Nwala, but also their last witness, Mike Enauro-Eba, PW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that would have supported the evidence of PW 21, 26, and 27, Mr. Samuel Odunton, Hitler Nwala, and Mike Enauro-Eba, have already been found incompetent and struck out by this court while ruling on the applications like preliminary objections of the respondents. Coming back to the objection of the respondents that paragraph 45B of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or note were not front-loaded with the petition are incompetent. Paragraph 45B of the first schedule to the Electoral Act 2022 reads thus. Now I want to mention it. It says the election petition shall be accompanied by B, written statements on oath of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party, ANDP, the INEC and two others, appeal number EPT 406/2020, and People's Democratic Party versus Okogbo, citation supplied on the issue. Where the words of a statute or instrument are clear, like paragraph 4.5b of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, the Democratic Party, NPU versus INEC, in appeal already cited, presided over by Justice Ige Nimpa and Agim, her colleagues, as Agim as he then was unanimous in his decision on the point in issue. Ige JCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 34554 of the first schedule to the Electoral Act 2010 are juxtaposed with Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call in proof of the petition, and more importantly, written statements on oath of witnesses. Well, there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath to witnesses and witnesses' statement on oath of a subpoena witness. There is no distinction between ordinary witness and subpoena witnesses under paragraph 4.5 of first schedule to the Electoral Act. In essence, paragraph 4.5 of first schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi and INEC, this court also decided over by my Lord Justice Samani JCA, the concurrence of my brothers Owade Kimbami, Balaji Yusuf, and Bayero JCA, again confirmed this position when in that decision was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the said witness was before the court on subpoena ad testificandum, but it must be realized that this witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the first schedule to the Electoral Act. It was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement or note was subject to the requirements of the law as stipulated by paragraph 4.5 of the first schedule. Strict compliance with paragraph 4.5 of the first schedule to the Electoral Act is mandatory. It's of such a nature that there is sanction in subparagraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okagwe, and then Ogba and Vincent, Midra and Patricia Ete, Awoyemi, Lasun and Awoyemi. All these cases have their citation here, and they already referred to in our earlier 3. Okay. It is of interest that in all these cases, the earlier decisions of this court, Midi Ram versus Patricia Ete and another, and Lasun versus Awoyemi, relied on strongly by Mr. Chris Uche SAN, what the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche SAN, the lead counsel for petitioners hearing, wrote a glowing forward to. The learned author, Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the extra position of this court in Omirira and Nete, and then Lasu versus Awoyemi. There, Chief Uche SAN, who is incidentally is present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in the long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omidiron versus Sete, see also Lasso and Awoyemi, citation supplied, wherein the Court of Appeal held that it would be appropriate to meet the justice of the case for a tribunal to order the filing of witness depositions by subpoenaed witnesses outside the stipulated time frame has been watered down, in that all evidence required in proof of the case must be brought within stipulated time frame. See the case of Ogba and Vincent, where the Court of Appeal, Agim JCA, as it then was in lead judgment, held, I think that this court in Omidira and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or a court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election proceeding. Omidiron's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006, the provisions in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing a petition and closure of pleadings, paragraph 1 of Election Tribunal and Court Practice Direction 2006, and the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal and court practice directions as overriding the rules of court in election cases. In Oke versus Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The law has laid out strictissima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus: if there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any person. There are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this, and the petitioner ought to have resorted to that procedure. Put this in italics, we have earlier mentioned it in 03. As earlier said, Chief Chris Uche SAN in his foreword to that book glowingly endorsed this author's position and even recommended it to judges like us in these words. The author has ably and remarkably sought to examine the legal framework of electoral legislation within the landscape of judicial decisions emanating from disputes arising from elections in the context of election litigation, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all stakeholders in the development of our constitutional democracy, unquote. I shall hold counsel to his words, not just because they are coming from him, but also because they are correct. Permit me to still say a word or two on petitioners' contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019 permitting parties to file witness deposition of a subpoenaed witness even after commencement of their action applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement as said of their witnesses filed by them after hearing of the petition had long commenced wherein were in order, full stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this act, the practice and procedure of the tribunal or the court in relation to election petitions shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modification as may be necessary to render them applicable having regard to the provisions of this act, as if the petitioner and the respondent were respectfully the plaintiff and the defendant in an ordinary civil action. This provision clearly makes application of the civil procedure rules of the Federal High Court in election petitions subject to the express provisions of the Electoral Act. It is not the other way around of modifying provisions of the Act to agree with the rules of the Federal High Court as suggested by Petitioners' Counsel. That much, paragraph 54 further clarifies by stating that even where the Federal High Court rules are considered applicable, they shall only apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this act. Unquote. What all that means is that where there is express provision in the act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the Electoral Act 2022, that says the election petition shall be accompanied by written statements on oath of witnesses, the provisions of the Federal High Court Civil Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Nwankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament have expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is also no moment that in the court's opinion, the say literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh, may not meet the justice of the case, as is being suggested by the petitioners that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that a witness on subpoena should also depose to a witness statement before the subpoena to compel the attendance is served on him by the court. If anything, the argument rather brings to mind the very strong admonition of the British House of Lords of Lords, Lord Denning MRL in Newport Steels Limited versus SIRS, citation supplied, where the learned Lord Scaman in his speech said, but in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law not to change it to meet the judge's idea of what justice requires. Interpretation does, of course, imply in interpreter a power of choice where different constructions is possible. But our law requires that the judge chooses the construction which, in his judgment, best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Palatable statute may not be disregarded or rejected merely because it's unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits his idea of what justice requires in any case. That is a settled position of the law, even in this country. See Ndomaegba and Shukwogo, citation supplied. Aromolara versus Aguru. Coca-Cola, Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, summarized aptly, wherein my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management so pre-hearing session as effectively as possible to carefully plan the future course and particularly its plenary hearing of every petition so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okogbu, and others, citations supplied, where my colleague Abadwa JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties and open the floodgates for all kinds of abuses of the judicial process. Quote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC. And then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of stare decisis, the decision in Oke and Mimiko and Ogba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuagu GSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW 12 Eguma Friday, PW 13 Grace Timothy, PW14, Grace Ajagbona. PW15, Abidemi Joseph. PW16, Ms. Edosa Obosa. PW17, Ms. Aleri Ayuba. PW18, Ms. Sadia Mohamed Aruna. PW21, Mr. Samuel Odunta, the statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulusado. PW25, Victoria Sani. PW26, Hitler Ewonu Nwala, forensic expert. And PW27, Mr. Mike Enahoroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2, 1A, PBD2A, PBD3, PBD4, PB1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4, coming from and tendered by the said petitioner's witnesses, namely, as I already listed, EW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objections raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only gave notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INEC, which documents parties had agreed at the pre-hearing session that they will not object to. So respondents cannot resile from that agreement and raise objection as they are doing. Even cited section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it, and it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and AfriBank and other authorities in that respect. As counsel, as ministers in the Temple of Justice are therefore within their right and in fact duty bound to draw court's attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I would have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Answer to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of July 2023. Second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under section 104 of the Evidence Act 2011 for certification of public documents. They said petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, PAJ to PAJ37, PAJ38, PAJ39A to F, PAJ40, PAJ41 to PAJ and PAJ41 to PAJ7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Then I cancel all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argue that certification fees for the said documents having not been paid by the petitioners, documents remaining admissible and liable to be expunged from the records. Petitioners in response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.123 of their response to second respondent, and paragraph 2.16 to 2.7 of their response to third respondent, that they actually paid certification fees to first respondent for their said documents, and that they were issued receipts by the first respondent. Some of those receipts, they said, were attached to the documents themselves, while others were separately receipted for, including in one instance, payment of 6,669,301 naira 25 kobo, and another for 150,967 naira 50 kobo. They argue that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Then Senior Counsel on petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that section 104(1) and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification fees were not paid for is clearly erroneous. Now, section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document. As required by subsection 2, payment of certification fees is only a condition precedent to the certification. So it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoma and Sodike, ANPP and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there evidence of certification fee payment by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to Exhibit PAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made by the receipt number RRR 270-842-653235 and on INEX receipt number 069727 of 25th of May 2023. It specifically states on its face thus the sum of 6,696,301 naira 25 kobo only, being payment for CTC IPO electronics of a copy of data level number data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded from EC9 and other documents 2023 presidential election unquote. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the said payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent, INEC, to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that it did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 104.1 of the Evidence Act, an applicant for certification of public document is only obliged to pay what is assessed by the public officer. What is more, the mere fact that respondents certified the said documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits PD and PAF 4C, sufficiently triggers the provisions of Section 168.1 of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal requisites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, it was also argued by the respondents relying on Belguri and Ahmed that certification of the same documents was done by public officer of INEC by engravement of his name, official title, and date instead of subscription, so that also, he said, is invalidated the documents and rendered them inadmissible. I've carefully perused the said documents and verified that unlike Belguri and Ahmed, the documents in issue here bear the longhand signature of the relevant certifying public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argue that exhibits PAH1, PAH2, PAH3, and PAH4 tendered by PW21 Mr. Samuel Odunta and exhibit PAR-A to F tendered by PW26 Mr. Hitler A. Nwala were made during pendency of this proceeding or in anticipation of it and therefore inadmissible in evidence by virtue of Section 83.3 of the Evidence Act 2011. In their response, the petitioners argued that the said documents were made pursuant to the orders of this court, pursuant to Section 146(1) of the Electoral Act 2022, permitting them to inspect documents, so they were properly before the court. Much as I am not oblivious of our earlier ruling, that these same documents coming from witnesses whose witness statements on oath were not front-loaded with the petition, are incompetent and so already struck out. I'm also of the opinion that the petitioners seem to 595 seem to completely misconceive the objection raised by the respondents, which is to the effect that the said documents, having been undeniably made during the pendency of this petition or in anticipation of it, are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011 and Section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach of that provision on account of the orders of this court made pursuant to Section 146 of 1 of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, Section 146(1) of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or packet in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners the leeway to adduce evidence in breach of Section 83 sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows the petitioner to file evidence, let alone the bulky expert reports as in exhibits PAH1 to 4, PAH1AF, PAR1A to F during the pendency of the petition. The whole idea behind Section 83.3 of the Evidence Act 2011 is to eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or was to produce such fresh evidence after the case had begun and parties had fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH1 to 4 and PAR1A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the said reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, C, D, and E, and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of Section 83 sub 3 of the Evidence Act 2022. Oh, sorry, Evidence Act 2011. Then the next one is inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them, and consequential irrelevance to the petition. The respondents' argument here are given. So we now skip that to the resolution. We've seen that, and the resolution we have is, it appears clear to me that the respondent's objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and his agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely Abia, Damawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Cross River Delta, Edo, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi, Niger, Oshun, Taraba states. Pleadings, they said, of party is not read in that isolated manner to get at a party's complaint. Pleadings must be read holistically to get at the complaint in issue. If that is done as it should be done, the respondents would have come across where petitioners left no one in doubt that their complaint about the election is nationwide and not isolated to only some few states. That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that the election results as purportedly declared by first respondent in respect of each state of the federation, including the Federal Capital Territory, the details of which are contained in the table below, and table was given, are wrong. Then they proceeded to list each of every state of the federation. They also gave in the table wrong election figures declared by INEC for each state and FCT. Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said averment. In paragraph 107 of the wrongness of the result declared by INEC for each state and the FCT, the presidential election. Among those documents listed by them are BVAS CTC reports, B, Forms EC8 series, then EC8A, EC8B, EC8C, EC8D, EC8DA, EC8E, that's certificate of return received by petitioners' agents at the election. C, summary of the total registered voters on units basis. D, summary of PVCs collected on unit basis. E, data and event logs from all BVA's machines used in the election. And F, PVC collation records. These documents were specifically listed at paragraphs 147.1, then 6, 36, 37, 56, and 57 of the petition. These are the same averments to documents respondents are asserting were not pleaded by the petitioners and so irrelevant and inadmissible in evidence. They are indeed wrong. This ambit of the objection of respondents is therefore overruled and rejected. Then objection made by only the third respondent. The next set of objections to documents tendered by the petitioners were raised by only third respondent. I now proceed to consider them. Admissibility of video clips. Arguments were advanced there on, okay. Okay. Yes. So we said, I'm however of the opinion that the contention is also misconceived, especially when regard is had to paragraphs 1, A, B, E, F, G of the certificate of authentication of the said video clips made by PW19 Dr. Ter. The authentication required by Section 84 of the Evidence Act in the circumstances the video clips in issue were made is statements assuring the court that they are in exact same state they were in the internet from where Dr. Ter, PW19, downloaded them to his laptop computer and subsequently to his flash drives before bringing them to this court. That much is evident in the contents of Dr. Ter's certificate in XBPAF 4B above. For the same reason, the argument of Dr. Ter is not the argument that Dr. Ter is not in position to answer questions on the said clips, and so his evidence on them is hearsay, is also non sequitur. Then there is also the issue of dumping of documents on court as ground for admissibility. With this one. Okay, that's part of the issue which will be considered deeply. Okay, you see, that is it. This is, okay. Some of them are listed. The simple and straightforward answer to this argument is that the issue of dumping of documents on court, which expression in any case suggests that the documents so dumped are already in evidence before the court, only goes to the weight to be attached to the documents by the court. On this reasoning, this ground of the objection is rejected and overruled. Then also there is allegation that some documents tendered were either made during pendency of this proceeding, I think we've seen that, and anticipation of it by interested parties. I think we've done a little consideration of this earlier. So we'll go to number 3. They said also that exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, and up to PBF4, tendered by the petitioners through PW27, Mike Enauro, to show second respondent's non-qualification for the presidential election on grounds of his alleged conviction stroke fine in the United States of America, forgery of certificates and dual citizenship are irrelevant to the proceeding and so inadmissible in evidence, petitioners having not pleaded necessary facts in their petition to support them. This also was looked at by us, and okay, and I have already ruled while considering the preliminary objection of the respondents to the petition and replies of the petitioners that paragraph 146 of the petition, where the petitioners averred to non-qualification of second respondent for 2023 presidential election, was bereft of facts to sustain it. I also held that the fresh facts of second respondent's conviction / fine by a district court in Illinois in United States alleged forgery of documents and dual citizenship, all of which petitioners only introduced for the first time in their replies, were incompetent. They ran foul of both paragraphs 4.1d and paragraph 16.1b are incompetent, liable to be struck out, and were indeed struck out. I'm also aware that we have just a few seconds ago ruled here in this judgment that evidence of PW27, though through whom they say the documents SB is now impeached by third respondent were brought in, is incompetent for non-compliance with paragraph 4.5b of the first schedule to the Electoral Act. Those rulings constitute issue estoppel, binding not only on the parties but on this court too, meaning further that this court cannot depart from them. See Francis Shano and Afri Bank, and also Lawal Daodo and Cardoso and Daniel and all that. Consequently, the objection of third respondent to the admissibility of this evidence earlier highlighted, the objection is hereby upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Summary of all the foregoing is that 1, the objection to the evidence adduced by PW12 witness Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona. Okay. Well, we said all those ones we have mentioned and also recouched here, we say that the objection is upheld, that evidence together with the documents, reports included, tendered by the same witnesses are hereby expunged from the records of this court. Secondly, the objection of respondents to exhibits PAH1, PAH2, PAH3, PAH4 made by Mr. Samuel Odunton, PW21, and exhibits PAR1A to F made by Mr. Hitler Wanwala, PW26, is also further upheld, and the said documents already held incompetent and inadmissible by earlier rulings are again hereby pronounced inadmissible in evidence on this ground too. Then exhibit, the third one now, exhibits, or the objection of third respondent to the admissibility of exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, PBD4, PBE1, up to PBF3, PBF4, tendered by PW27, Mr. Mike Enauroeba, is also upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Save for these ones mentioned above, all other objections of the respondents to documents tendered by the petitioners are overruled. Well, at this level, I hand over, like my brother said, to my leader to continue with the judgment. Thank you.
Well, I now consider the substantive matter, the substantive petition. I however wish to state that despite our conclusions above on the objections raised by respondents to documents tendered by the petitioners, I am still mandated to evaluate evidence adduced and consider merits of the petition. The only evidence I shall not revisit are exhibits PBD, PBD1A, PBD1C, 1B, 1C, 1D, 1 PBD1A, PBD2A, PBD3, PBD4, PBE1, 2, 3, 4, 5, 6, PBF1, 2, 3, 4, and 4, relating to second respondent alleged non-qualification that were tendered by PW7 at 27. Mr. Mike Enauroeba, the said documents, in our view, being bereft of pleadings to sustain them, as a liberal stated earlier in this judgment. Coming to the hearing, the petitioners called a total of 27 witnesses and closed their case on 24th June 2023. The respondents opened their respective defenses starting from 3rd day of July 2023. The said respondent called one witness as one of its staff, RW1, and closed his case. The second respondent also tendered documents and called one witness, RW2. The third respondent did not call any witness but tendered documentary evidence. At the close of the case of the parties, the court ordered written addresses. The addresses were filed and scheduled. In the final address for the first respondent filed on 14 July 2023, the learned leading senior counsel of first respondent, Mr. A.B. Mahmoud SN, raised 4 issues as follows. 1, whether having regard to section 47, subsection 2 and 3 of the Electoral Act 2022, paragraphs 38 and 92 of the regulations and guidelines for the conduct of elections 2022, and totality of evidence adduced at the trial, the inability of the first respondent to transmit the polling unit results electronically in real time using the BVAS device to the IRF portal constitutes non-compliance with the Electoral Act if such substantially affected the outcome of the presidential election held on 25th day of February 2023. 2, whether there exists cogent and credible evidence of corrupt practice to warrant the nullification of the presidential election held on 25th day of February 2023. 3, whether going by the provisions of section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended, the second respondent was at the time of the presidential election held on 26th day of February 2023 not qualified to contest the said election. 4, whether upon proper construction of section 134(2)(b of the Constitution of the Federal Republic of Nigeria 1999, the requirement that a candidate must score not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation as the Federal Capital Territory, Abuja, means that a successful candidate must specifically score at least 1/4 of the votes cast in the Federal Capital Territory, Abuja, in addition to 2/3 of all the states. The second respondent, through his counsel, Wale Olani Pekun, SAN, filed his written address on 14 July 2023. He raised for determination 4 issues which were listed as follows. 1. Considering the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and or provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the peculiar circumstances of this petition, wherein the petitioners pleaded no fact in support of their allegation of non-qualification of the second respondent, whether the second respondent was or is not eminently qualified to contest the presidential election of 25th February 2023. 3. Upon a combined reading of Section 134 and 299, as well as other relevant provisions of the Constitution, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitution of the petition and the third evidence adduced, whether this honorable court can accede to any of the reliefs being aimed at claimed by the petitioner. The third respondent, through her lead counsel, filed its final address on 14 June 2023. Similarly, 4 issues were generated for determination. 1. Whether, having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25th day of February 2023 was vitiated by non-compliance and corrupt practices that was substantial enough to direct or directly attributed to the second respondent as to have affected the outcome of the election and to justify notification of the election in a manner envisaged by the applicable provisions of the Electoral Act 2022. 2. Whether the burden of proving that first petitioner and not second respondent caught majority of lawful votes cast and satisfied the constitutional requirement of having 1/4 of the votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25th February 2023 has been discharged by the petitioner. 3. Whether, having regard to the issues joined and evidence led on the qualification of the second respondent to contest in the presidential election held on 25th February 2023, the petitioner has established that second respondent was not qualified to contest the presidential election as provided for in the Constitution and the Federal Republic of Nigeria 1999 as altered. And 4. Whether, having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the reliefs sought in the petition at all, or that the petition ought to be dismissed in favor of the respondents. In response to the addresses filed by the first, second, and third respondents, the petitioners, through their leading counsel, Chief Chris Uche, SAN, filed their respective written addresses on 21st July, 22nd July, and 23rd July 2023. The petitioner's senior counsel filed separate written addresses in response to each of the first, second, and third respondent addresses. The issue for determination raised in the 3 written addresses filed by petitioners in response to each of the written addresses of each of the respondents are the same, and they are: 1. Whether the return of the second respondent in the election to the office of the President of the Federal Republic of Nigeria held on 25th day of February 2023 was not invalidated by reason of substantial non-compliance with the provisions of the Electoral Act 2022 on electronic transmission of results for collation and verification. 2. Whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja, as required by the Constitution of the Federal Republic of Nigeria 1999, as amended. 3, whether the second respondent was not disqualified under the provisions of the Constitution of Federal Republic of Nigeria 1999 as amended to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from that related offense, his acquisition of the citizenship of a country other than Nigeria and presenting a forged certificate to the first respondent. 4, whether the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of the lawful vote cast in the election. A look at the issues formulated by the parties will show clearly that though differently worded, they are similar in context and content. It is in the face of this that we choose the 4 issues formulated by the petitioners, albeit with necessary modifications to anchor the determination of this petition. The issues for determinations as modified are as follows. 1, whether the return of the second respondent in the election to the office of President of the Federal Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. 2, whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja. 3, whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria as amended to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from the drug-related offense, his acquisition of the citizenship of the country other than Nigeria, and presenting a forged certificate to the first respondent. 4, whether the second respondent was duly elected by majority of the lawful votes cast in the election and the first respondent was right in returning him as duly elected. So we go to issue number 1, which is whether the return of the second respondent in the election to the office of President of the Federal Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. Yes, we have considered the submissions of counsel which we have summarized here. So we'll just go straight to the resolution of that issue. This issue of non-compliance is directly standing on the first ground of this petition. Thus, by paragraph 16A of the petitioner stated that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. By section 1341B of the Electoral, non-compliance with the Act is a ground for questioning or challenging an election. Primarily, the law is well settled that the results declared by any first respondent in an election enjoy a presumption of legality. In other words, they are prima facie correct. Section 168 of the Evidence Act 2011, recently applied by the Supreme Court in Atuma and INEC and APC. Where in JSC held as follows. By virtue of Section 168 sub 1 of the Evidence Act 2011, presumption of regularity inures in favor of judicial or official acts, including those carried out by INEC. The exact words of The subsection are thus: when any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that formal requisites for its validity were complied with. Fortunately for the appellant and first respondent, it is only a presumption which implies that it is rebuttable. Any person who questions the validity of an act in favor of which there is a presumption of regularity has a duty to rebut the presumption with cogent and credible evidence. A flimsy or half-hearted rebuttal will not suffice. Close of court. Any petitioner who complains that the result as declared is either wrong or not in compliance with the Electoral Act has the onus of proving the contrary. See Newsom Peter side. This case was laid open by the Supreme Court in the case of Andrew and another versus Annie, where the Supreme Court, per Onogen JSC, held as follows. Well, the term is far gone. We'll keep those quotations. When you get the judgment, you will see. Generally, it is the law that he who alleges must offer the requisite proof. The petitioners have the burden of proof, and they must succeed on the strength of their case as per their pleadings. The level of proof required is twofold. The first level is that there is non-compliance. The second level is to prove that the non-compliance substantially affected the result of the election. The learned senior counsel for the petitioners in this petition argued that the burden of proof is on the person asserting the positive and not on the person asserting the negative. The petitioners, it appears from their position, tend to cross the line of misconception as to who has the burden of proof in adversarial system of justice in civil cases when the primary onus of proof is on the petitioner who makes all the claims against the respondent in this case. Well, we had started this case of Daché and Druven by Ugo JCA in the earlier petition just determined. That's petition number 3. Usually the burden of proof is the debt owed by the petitioners to the success of their petition. The burden of proof rests upon the party who substantially asserts the affirmative of the issue. It is fixed at the beginning of the trial by the state of the pleadings. If the party with the burden fails or could not discharge the burden, the decision must be against him. The case of Adegoche and Adibi Supra, relied upon by the petitioner, was cited in the recent case of Folarin and Augusto, where the Supreme Court by Okoro JSC held as follows. The quotation is there. It is therefore settled that the terms negative and affirmative are relative and not absolute. The burden of first proving existence or non-existence of an assertion or fact, whether positive or negative, lies on the party against whom judgment will be given if no evidence were produced on either side. In the instant case, it is fundamental to point out that from the pleadings, the allegation of non-compliance is generated by the petitioners. Under Section 1341 and 135 of the Electoral Act, the level of proof required for the success of the petition is doubled. There must be proof of non-compliance and the further proof that the non-compliance affected substantially the result of the election. In the face of such an allegation of non-compliance, the court is enjoined by the law not to invalidate an election if it appears that the election was conducted substantially in accordance with the principles of the Electoral Act. All said and done, the petitioners have the primary burden of proving that there was non-compliance and that the non-compliance affects substantially the result of the election before the burden can shift to the respondents to establish that there was no substantial non-compliance with the Electoral Act in the conduct of the election. If petitioners have in their petition pleaded some of the facts relating to their complaint of non-compliance to the Electoral Act 2022, the key paragraphs of their petition in that regard are paragraphs 18, 22, 23, 25, 28, 29, 35, 36, 37, 38, 39, 40 to 44, 47, 48 of the petition. The respondents joined issues with the petitioners in respect of this issue, and they all denied the facts pleaded by the petitioners. The denials of the first respondent in its reply are very significant. in paragraph 17, 18, 19, 31, 32, 33, 34, 35, 36, and 37 of the first respondent reply to the petition. The first respondent is in great measure denied all the allegations of the petition. In the petition, since those paragraphs are direct and straight denial by the first respondent, the burden of proof remains on the petitioners to establish their claim as required by the law. Apart from the first respondent, who is the primary respondent, due to the fact that it is its acts that are challenged in this petition, the second and third respondents, who are the beneficiaries of the declaration of the results, join issues with the petitioners. The second respondent, in its reply to the petition, countered all the petitioners pleaded in respect of the issue. Issue 1 with paragraph 6, 33, 56, and 57 thereof. The third respondent countered the petitioner's allegation with paragraph 26, 37, and 40 of its reply to the petition. Non-compliance in ordinary parlance means failure to or refusal to do something that you are officially or statutorily supposed to do. See Shulua and another versus To J.I. 13, Ojuku and Yaradua and Akirdu and Mimiko. The Electoral Act 2022, in an explicit manner, has laid out clearly grounds upon which an election can be questioned in section 134 thereof. Then there is section 135 of the Electoral Act, which looks like it provides to section 134 for proper appreciation of the intendment of the law. Section 134 and 135 of the Electoral Act must be considered together. Well, an election may be, 1341 says, an election may be questioned on any of the following grounds. B of it says the election was invalid by reason of corrupt practices or non-compliance with the provisions of this act. Then 135(1) says an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this act and that the non-compliance did not affect substantially the result of the election. This ground of non-compliance to the Electoral Act has been in all our electoral laws, even from when we had parliamentary system of government. The courts have, over the years, shed a lot of light on the requirement of the law in proving the allegation of non-compliance. A short chronicle of the decisions of our courts will throw more light on the evidential burden of proving non-compliance. For that purpose, we cited the cases of Bassi and Young, Awolowo and Shagari. We also cited the cases of Buhari and Anada versus Obasanjo and others, and CPC versus Buhari and others. So in all these decisions, the evidential burden of proof of non-compliance lies on the petitioner, who must first prove that there was non-compliance, and secondly, that the non-compliance has substantially affected the results being contested. Let me say that at the risk of sounding repetitive, that it is after the onus on the petitioner is discharged to the satisfaction of the court, that the onus will shift to the respondents to establish that the results were not affected. It follows, therefore, from the authorities referred to, that for the petitioner to succeed in the allegation of non-compliance, they must plead clearly in their petition the non-compliance and call witnesses or place before the court cogent and credible evidence of such non-compliance. The petitioners need to place before this court evidence based on their pleadings, indicating that the non-compliance has affected the votes cast at the election and that the impact is substantial enough to invalidate the election. The petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collection centers, local government collection centers, and state collection centers in all the states of the Federation and the Federal Capital Territory, as well as the National Collection Center. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicates of results from EC8A. The few agents called were state and national collection agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraphs 7, 8, and 11 of his statement, he deposed that from his analysis, he discovered various forms of non-compliance and corrupt practice such as suppression of votes, manipulation of Beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumbprinting of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of multiple thumbprinting at the polling units. In PDP and ANEC and others, this court, per Agim Jesse as it then was, held that it is only a polling unit agent, or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in the unit. See also Goyol and Anada versus ANEC, Buhari and ANEC and others. In the instant case, PW1 was not a polling agent, he was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling unit agents in all the polling units and that they are still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. His name is Dr. Solarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW 3, 4, 5, 6, 7, 8, 9, 10, 11, and 11 are all collation agents. The evidence of these witnesses centered around the events and the duties carried out by the polling unit agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units. Under our law, specifically in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or her principal. Having regard to the fact that no mortal can be in all the places at the same time, the law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by the law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows therefore that PW1, 2, 3, 4, 5, 6, 7, up to 11, PW 19, 20, and 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of the analyzing results of the election of the ward, local government, and state and national level without calling polling unit agents who witnessed the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. This court and the Supreme Court in several cases has explained the intent of this legislation. But that started JAM and OG, Ute and the state Kasa and the state Ukud and the state Buhari and Obasanjo. It is therefore settled law that hearsay evidence is not admissible to prove a fact of non-compliance with the Act. It follows that the evidence of the collection agents in this case, instant case, who are PWs 1, 2, 3, 5, and 7, relating to the suppression of votes, multiple tampering of ballot papers, entering of wrong scores, results, disruption of voting, are inadmissible hearsay and are hereby discontinued. In the instant petition, the petitioners called 27 witnesses and tendered documents and exhibits. The main and crucial complaint of the petitioners from the evidence placed before the court was the inability of the presiding officers employed and used by the first respondent to upload and transmit the polling unit results to the first respondent's result viewing portal, that's IREF, and the electronic collection system. Of the 27 witnesses called by petitioners, 10 of whom were presiding officers who manned some polling units on the election day. A look at their evidence will bring out the facts of how the presidential election was conducted in some of the polling units on 25th February 2023. These witnesses are PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25. PW 12 is Yoguma Omachuku. The witness was on subpoena. He was the presiding officer in Collation Unit 07, Ward 3, Aba North of Abia State. His evidence is that the election was conducted as his polling unit and that at the end of the election, the results were recorded on the result sheet and duplicate copies given to the party agents at the polling unit. He stated that he had challenges in uploading the presidential election results from his polling unit to the IRF portal and electronic collation portal. When cross-examined, the PW12 testified that the election was peaceful and that it was the image of the result on Form EC8A that was supposed to be uploaded to the IRF portal. He further testified that the result sheets were delivered at the Ward Collation Center to the annual Ward Collation Officer. He said he was happy with the conduct of the election. PW13, Grace Timothy, who was the presiding officer for a polling unit in Bauchi State, corroborated the testimony of the PW12. She could not upload the result of the election to the IRF, but that the party agent signed from EC8A and that she took the original result to the Ward Collation Center. PW14, Grace Ajabona, whose petition was polling unit 6, Ward 1, Yaba West, local government area of Kogi State, equally testified that the election result from her unit from EC8A was signed by her and all the party agents before she took the result to the Ward Collation Center. The PW15, Abidemi Joseph, was the presiding officer in charge of polling unit 047, Ward 9, Maji of Babambola community in Maji, Suleja, Niger State. She gave the evidence also that election was conducted in her unit and that the results were signed by her and the party agents before she took it to the Ward Collation Center. She also could not upload the result to the average viewing portal of INEC. The PW16, Idosa Obosa, was the presiding officer at polling unit 09, Welu Health Center, Ego Ward 05, Edo State. She equally testified that even though voting went well in the election at her polling unit, she was unable to upload the result of her unit to the RF using the beavers. She did the manual recording of the results into Form EC8A and signed the result along with the party agents. The result was equally taken by her to the Ward Collation Center. The same story was told by the PW17, Alheri Ayuba, who presided at the polling unit 05, Garki Ward 02, FCT Abuja. She used beavers for accreditation of voters, but could not upload the results through beavers to IRF. She and the party agents signed the results, and she took the results to the Ward Collation Center. Even the testimony of Mohammed Haruna Sadia, the PW18, is in the same order. He was the presiding officer for Unit 05, Amak City Center, Ward 06 in FCT Abuja. She testified she could not also upload the results to the RF. She entered the results manually to Form EC 8A and took it to the Ward Collection Center. She testified that she gave copies of the result to the party agents before taking the original to the Ward Collection Center. Janet Nuhu Turaki, the PW23, who was the presiding officer for Bolori West, Ward 04, AB Bomala Danladi Jalo Polling Unit 0, could not upload the results to IRF after using beavers to snap the result as recorded in Form EC 8A. She, however, testified that the party agents signed the results with her before she took the results to the Ward Collection Center. The same run of evidence was given by PW24, Christopher Bulus Arro, presiding officer in Maru Ward 04, polling unit 012 years, Sohor Kaswa, Maru, Zamfara State. In paragraph 9 of his deposition on oath, he said the election was successful except for failure to upload the results to the RF. The PW25, Victoria Sani, who was the presiding officer at polling unit 020, Ward 01, Atagarawa local government area of Katsina State, had the same testimony and experience with the beavers and the issue of uploading results to RF. The testimony of these witnesses were so clear and cogent that the election went well. The only difficulty was in uploading the results to the RF portal. These highlighted witnesses were all called by the petitioners. The witnesses were emphatic that the voting and the election in their respective units went well. The votes were collected and results announced at the polling units. Party agents signed the result from EC8S. The witnesses called to establish the fact of non-upload of results emphatically and directly testified that the election went well and votes were accounted for and sent to the Ward Collection Center for collection of the results. These 10 witnesses were all presiding officers engaged by the first respondent for the election of 25th February 2023. There is no gainsaying the fact that under the Electoral Act 2022, election is not just a process, it is a well-regulated process. In fact, in the case of OK and another versus Mimiko, the Supreme Court Odiligency scripting out the meaning of election held as follows. On this first issue, I will want to hang for support on the case of Abubakar and Yaradua, in which election was defined thus. Election is a process spanning a period of time and comprises a series of actions from registration of voters to polling. Then in Bile and the state, the court, Paanguta JSC, explained further that election is defined as inter alia, the act of choosing or selecting one or more from a greater number of persons, things, causes, or rights. See Black's Law Dictionary Special Deluxe, 5th edition, page 464. The Oxford Advanced Learners Dictionary, page 372, defined it as the action or an instance of choosing by vote one or more of the candidates for a position, especially in political office. The process of election commences with the nomination of candidates through political party primaries. Then it moves into the election proper, which entails the voting, collection, announcement of results. To make this process steady, clearer, and credible, the Electoral Act devotes time into making provisions for specificity of actions and steps at each stage. It will not be out of place, my lords, considering the strategic and fundamental nature of election, to survey some of the provisions of the law in this respect. The law made provision for accreditation of voters and voting in Section 47 of the Act, which provision I have reproduced in this judgment. This law has made it mandatory for accreditation of voters for the election to be done with the aid of a smart card reader or any other technological device that may be prescribed by the first respondent. The first respondent exercised the discretion given by the law to prescribe the use of bimodal voter accreditation system, that's BVAS for short, and popularly known as BVAS or BVAS machine. As the name indicates, BVAS is primarily a technological device for accreditation. By paragraph 18A of the regulations and guidelines for the conduct of elections 2022, the use of BVAS for accreditation is mandatory, and all the poll officers who fail to use it for accreditation shall be accused of dereliction of duties and penalized. It is after a voter passes accreditation that he will be allowed to vote. The bottom line of every election exercise is to choose one out of many or to show affirmation of the approval of a candidate who wins the election to lead the country in the instant case as the president of the country. To achieve this goal, election must be result-oriented and successful. A successful election must produce a winner who is expected to emerge by popular vote and as specified in Section 134 of the of the 1999 Constitution. It is in this respect that all votes cast at an election must be duly secured, collected, and counted. The Electoral Act is so clear and explicit when the issue of the votes cast and the results of the election. So for that purpose, I produced Section 25 of the Electoral Act, which stipulates the steps to be followed. So this provision makes it clear and straightforward that voting for all elections takes place at the polling units, and that is where the election is won or lost. The law requires that since the election, the present election, unlike others, is not done in one location but throughout the country, collection of votes commences at the registration area through ward level after voting, then it moves to the local government level, and then to the state collection center, and finally to the national collection center. It is after this that the winner of the election shall be announced. Furthermore, Section 60 and 60 of the Electoral Act deal with the counting and collection of votes cast. These provisions of the Electoral Act are very simple, plain, and straightforward, and do not require any technical rule of construction. The law is tried that where words used in the statute are clear and unambiguous, the courts are enjoined to interpret the words in their ordinary and natural meanings. Words used are to be interpreted in a way that will not clash with and defeat the manifest intention of the legislation. Every legislation is scripted by the lawmakers with a purpose. The court must be careful not to interpret the law so as to create absurdity or make nonsense of the law. See the cases of Imiano and others versus Anekwe and others, Jegede and Anek, Guma and versus APC and others, Lado and another versus Masari and others. The law as prescribed in Section 60 and 62 of the Electoral Act 2022 does not in any form or sense make any provision or pretension as to any form of counting and collection of election results other than manual collection. In Oyetola and Anik Supra, the Supreme Court, per Agim JC, held on transmission of results, the essence and status of the collection system, and the Anik RF portal as follows. Court, as I had held herein, there is no part of the Electoral Act requiring the presiding officer to transmit the accredited voters in the polling unit or the polling unit results during election to the ANIC database as part of the election process. As stated in Section 62(1) of the Electoral Act 2022, after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their polling units, polling agents, where available to such person as may be prescribed by the Commission. This is to enable the Commission compile, maintain, and update on a continuous basis a register of election results. This intention is clear from subsection 2 of Section 62, which provides that the Commission shall compile, maintain, and update on a continuous basis a register of election results to be known as the National Electronic Register of Election Results, which shall be a distinct database or repository of polling unit by polling unit results, including collected election results of each election conducted by the Commission in the Federation, and the register of election results shall be kept in electronic format by the Commission at its national headquarters. As their names depict, the collation system and the annex result viewing portal are part of the election process and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. It is clear from the positions of Regulation 38(1) and 2 that the collection system and result viewing portal are different from the National Electronic Register of Election Results. The collection system and result viewing portal are operational during the election as part of the process. The National Electronic Register of Election Results is a post-election record and is not part of the election process. With this state of the law, let us now assess the case of the petitioners in this petition. The petitioners, as earlier mentioned in this judgment, are claiming that the failure of the first respondent to upload the election results constitutes non-compliance to the Electoral Act. They pleaded in paragraph 14 and 15 of their petition. Thus, I've reproduced paragraph 13 and 14. So the petitioners, by this pleading, are relying on the summary of final collation and declaration of results, which are in forms ECDA, in bracket, ECAE, as issued by the first respondent. The issues generated on this were not about the scores, but the alleged invalidity of the scores and the error of calculation of the scores. This pleading was not admitted by the first respondent. In reply, the first respondent joined issues with the petitioners in paragraphs 9, 10, 11 of their reply filed on 11 April 2023, which paragraphs are reproduced. It is settled law that issues for trial by the court are joined in the pleadings, and the parties and indeed the court are bound by the pleadings of the parties. The petitioner's case stands to collapse if no evidence is called on the issue. See the case of Oruwari and Osler and Nada versus Dixon. In the instant case, the petitioners anchored their case in this issue, on the report of the statistician, forensic examiner, and other experts. The statistician's report referenced by paragraph 14 and 15 of the petition was tendered in court through PW21, Mr. Samuel Oduntan. It is filed on 14th of June 2023. The statistician's report were tendered, admitted, and marked exhibits PAH1, PAH2, PAH3, and PAH4 respectively. This report was challenged by the respondents, and in our earlier ruling, we came to the conclusion that it was incompetent and liable to be struck out and was in fact struck out. Without prejudice to that ruling, I wish to assess its value. Nevertheless, PW21, the maker of the said reports, was cross-examined in court by all the respondents, and he showed clearly that he is an unreliable witness. He was contradicting himself on issues around his report, apart from the fact that this witness is a subpoena witness whose witness statement of oath was not front-loaded. He did not present himself as a credible witness. Hear him under his cross-examination by Mahmoud SN for the first respondent. He said, I have formal training in information technology, IT, as stated so in my written statement. I was commissioned by the petitioners. I was compensated by the petitioners for my work. I am an expert in statistics. Apart from what I stated in paragraph 5 of my witness statement, I have enough experience in my work and election petitions. One does not need to be an expert to read ANEC forms EC8S. I commenced my work sometimes in April. It took me about a month to complete my assignment. I cannot recall any proceeding where I admitted that I am not an expert. I agree that if my primary data is defective or incomplete, my conclusions could not be wrong or incorrect. I could be wrong or incorrect. I also agree that if my methodology is wrong, my conclusion will be wrong. I have seen page 4 of Exhibit PAH1. That page refers to the methodology I use as referring to Forms EC8S. I inspected the Forms EC8S at the ANIC headquarters. I do not know if those Forms EC8S are before the court. I am aware that the Form EC8S are stored in the various state headquarters. If what are stated in paragraph 2 at page 4 of Exhibit PAH1 is wrong, my conclusion will be wrong. I have seen column 1 of volume 3, Exhibit PAH4, at page 1, line 1. It refers to polling unit 009, ward 6 of Anambra State. When cross-examined by Chief Olani Pekun ACN for the second respondent, the PW21 said, I have seen paragraph 5A of my written statement on oath. It is true that I did not present the report in Khalil and Yaradua. I agree that no pictorial images of the electoral documents I referred to in my statement are attached to my statement. I am aware that PDP won the election in Adamawa State. By my report, we are not satisfied by the votes returned by ANIC in Adamawa State, including the votes scored by the first petitioner. I say so because I am not satisfied by irregular votes recorded in Adamawa State. That is why I sought the deduction of those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score for PDP in those states because they are printed with irregularities. I'm also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the situation room of the PDP on the day of the election. I have seen the report for Kano State in Exhibit PAH2. Furthermore, in response to the cross-examination of the Learned Senior Counsel for the third respondent, Fabian ESN, the PW21 said, it is true that I have been following ANIC activities since 1999. There was a time that ANIC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANIC chairman announce 2 days to the election that due to security and cash crunch, elections will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. As stated the role played by each of those persons, I have seen volume 3 of my report. The said volume 3 of my report deals with ANIC documents, which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's votes cannot be deducted more than once in a unit. I did not conduct extraction of the BVAS report. I'm aware that BVAS machine was used for accreditation. I'm the only one who signed the report because I was the team leader. I worked in all the states where alteration took place, including states where PDP won. That's the treatment of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, Supra, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It is in the instant case, it has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost esteem and value. A close look at the reports, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, wherein he claimed that from EC8A series were altered and would not sign. It also talked of 15,002 polling units where Form EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several forms EC8A series had a lot of alterations and that they were not signed by the presiding officer. The law particularly requires that the presiding officers must sign the results. Signing Form EC8A is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature from stamp and any alteration on the forms. Since PW21, who authored exhibits PH3 and PAH4, did not place this in his report, and the petitioner did not call any of the polling unit agents to testify and place the forms before the court to give vent to the allegation of alteration and non-signing of the Form EC8S for the 5,270 polling units listed in Exhibit PAH2 and the Form EC8S not signed, stamped for the 15,002 polling units in Exhibit PAH3. That allegation is unfounded and not proved as required by the law. On petitioner's allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines made it mandatory for electronic collation system. I have carefully considered the submission of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent herein, is established by Section 153F1F of the Constitution, and part of its functions stated in paragraph 15, item F, part 1 of that schedule to the said Constitution is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulates its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area council of the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) says that a collection officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 64. At this stage, it should be noted that Section 47(2) referred to in Section 64(4)(a) relates to procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64, subparagraph 4B of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 or Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner as prescribed by the Commission. The Act also provides in Section 60, subsection 5, that the collection officer or return officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collection or returning officer will use to verify and collect the results, subsection 5 also provides for what the collection or return officer will use to collect the results. Subsection 6 of the same section provides for what the collection or returning officer will use to determine the correctness of disputed result where there is a dispute. These are the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed collected result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, sub 2 of this Act. And D, the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 60, subsection 4 of the Act, which requires only the accounting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the words deliver in Section 61, transfer in Section 65, and transmitted directly in Section 50, sub 2, 64, sub 4, 5, and 6 of the Electoral Act in stating how results of election should be handled under those provisions. A look at the definition of those words in the Black Law Dictionary 6th edition show that the word transfer is defined at page 1497 as to convey or remove from one place or person to another, or to pass or hand over from one to another, or to specifically change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly interchangeably to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all this, the Electoral Act 2022 has not specifically provided that the results of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1999 Constitution, and Section 148 of the Electoral Act 2022 that the first respondent herein made the regulations and guidelines for the conduct of elections 2022, as well as INEC Manual for Election Officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation on non-compliance on paragraph 38(1), Roman 1 and 2, 48A, B and C, 50, Roman 5, 7 and 20, 51, Roman 2, 54, Roman 12, and 55, Roman 12, and paragraph 93 of the regulations and guidelines. Paragraph 38, those provisions refers to have been reproduced in this judgment. So from the foregoing provision of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 621 for the delivery by the presiding officer of the result, along with other election materials under the security and accompanied by candidates or their polling agents, were available to such persons as may prescribed by the first respondent. The first respondent has, by paragraph 30 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area for ward collation officer. As stated earlier, the technological device prescribed by ANIC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or his fingerprints or face, that's facial recognition, thus accrediting the voter to vote at the election. And storing the data and number of such accredited voters. By paragraph 38, Roman 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC88 to the annual result viewing portal, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area for ward collation center. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload same to the result viewing portal RF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It should be noted that ANIC results viewing portal RF is not a collection system. Thus, the Supreme Court in Oyetola and ANIC has explained the difference between the collection system and RF, where again JSC held as follows. As their names depict, the collection system and the ANIC result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit's results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collection. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day, close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of election 2022, and the ANIC Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the result, the presiding official shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANIC manual, also state that hard copies of election results shall be used for collation, and it is only where such hard copies of the election results exist. No such hard copy of the election results exists, that electronically transmitted results or results from the ANIC will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that it's substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations asserted by them. It is important to note here that although election petitions are sui generis, they are governed by the Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instance case, from the myriad of decisions, the onus is directly on the petitioners not only to establish such through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akinlade and another was ANIC, Audu and ANIC, Oke versus Mimiko, Kente and Ishaku, Nda Kene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This is section 66 and 68 of the Act, which have been produced in this judgment. By the law, results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the president as in section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling units. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of votes, collation and announcement of results, signing of result forms, and publication of results. The results sought by the reliefs sought by the petitioners are declaratory in nature. It is cited in law that where a petitioner seeks declaratory reliefs, the burden is on him to establish his claim. His success is on the strength of his own case and not on the weakness of the defense of the respondents or defendants. See, missionary and Arebeshola and Oga versus Piazzo. It is also the law that the pleading and the claim of the petitioners determines the burden and the standard of proof that is required. By Section 135 of the Evidence Act 2011, if the commission of a crime by a party to any proceeding is directly an issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. See the application of this provision in the cases of PDP and IG versus PDP and others, APC and another versus Obaseki and others, Suleiman and others versus APC and others. In all these cases, the position of our law is that whenever crime is alleged, even if the case is a civil case, its proof must be that of beyond reasonable doubt. In the instant case, the petitioners have grounds of non-compliance with the Electoral Act 2022 and allegation of corrupt practices. Section 134(1)(b) refers to the ground of corrupt practice or non-compliance. If the ground pursued in any petition is simply non-compliance with the Act and there is no tincture of allegation of crime, the proof required would be on the balance of probabilities. But the standard of proof in any ground that is primarily on corrupt practices would require proof beyond reasonable doubt that allegation being criminal in nature. In the instant case, and on the issues being resolved here, the petitioners tendered some documentary evidence directly from the bar. The objections to the admissibility of most of the documents had earlier been dealt with by this court in the earlier ruling on the objections as to the admissibility of the documents, and some of them have been held inadmissible in evidence. The petitioners called 2 star witnesses alongside other witnesses. The star witnesses are PW19, Dr. Alex Adum Ta, and PW22, Senator Dino Melai. The sworn evidence on oath of PW19 is at pages 131 to 160 of the petition. In paragraph 23 and 30 of his sworn deposition, Dr. Ta, that's PW19, said as follows: I know that on the face of the form EC8G, 8 in A in bracket, there are calculation errors as shown and contained in the report of the statisticians, which the petitioners shall rely upon. The non-compliance consists of refusal to authenticate all the intending voters in the election using the technological electronic device prescribed by the first respondent, in addition to failure of the first respondent to transfer the outcome of the election directly into the portal of the first respondent created for the viewing of the public as a means to ensure the integrity of the election at the polling unit, and the electronic collation system before the declaration as to who is the winner of the election. There are no particulars supplied in his statement on oath All that can be read from this statement are projections without substance. When he was cross-examined by A.B. Mahmoud SN, he said that it is true that I am a lawyer and politician. I am the national coordinator for the petitioners. I was at the National Collation Center. I was throughout. Okay, it's up to here. Well, the cross-examination without witness has been reproduced. It's a bit then. Since they sworn the position on oath of the next star witness or the petitioners, PW22, Senator Diallo Melai, is almost a rehash of the entire petition. What he said on cross-examination by A.B. Mahmoud has also been reproduced. The testimonies of these star witnesses under cross-examination aggregated the same account given by other witnesses that the election went well. Accreditation with the Vivas device was all right. The agents of the petitioners were on ground at the polling units, and that the results were entered on forms EC8As and duplicate copies given to the agents. The facts elicited from the cross-examination of these witnesses have belied much of the strands of their written statements on oath. This, of course, is a challenge to the credibility of the evidence of PW19 and PW22. While cross-examination has the capacity to tarnish the credibility of a witness, it also has the corresponding capacity of strengthening the case of the opponent. In the instant case, the evidence elicited from the PW19 and 22 on cross-examination has fortified, in my opinion, the case of the respondents that there was nothing wrong with the results of the 2023 presidential election and that there was substantial compliance with the Electoral Act 2022. That also played out in the cross-examination of PW20, Olatunji Oshele. His deposition on oath is at page 204 to 207 of the petition. That is the same trend in the account of these witnesses. They were majorly given account of not only the polling stations they voted, but other places not within their reach. The significant tone is that they testified of casting their votes without any problem. The results by their admission were properly declared and taken to the court collation centers. The irony though, is that the witnesses, is it okay? The irony, though, is that the witnesses did testify to a peaceful and valid election in their polling units where they voted and then turned around to give evidence of alleged infractions in polling units where they were not present. Their testimonies in that respect are hearsay. Hearsay evidence is not admissible and has no value in proving the petition filed by the petitioners. Furthermore, in the instant petition, first respondent is consistently maintained that the technical glitch that occurred on the election day was the failure of the e-transmission server to upload polling unit results for the presidential election into the IRF portal. It claimed that the glitch only prevented the members of the public from viewing or accessing the results that were already uploaded and listed on the first respondent e-transmission system. On their part, the petitioners asserted in their petition that the glitch claimed by the first respondent was actually a bypass by the first respondent to tilt and switch the results of the presidential election in favor of the second and third respondents, as pleaded in paragraph 40. In furtherance of that assertion, they also pleaded in paragraph 40 1 and 42 of the petition as follows. The petitioners applied to the court for subpoena to issue to the witnesses listed in paragraphs 41 and 42 of the petition on 26/5/2023. These witnesses were not called by the petitioners, and no reason was given as to why they backed down from calling the witnesses they pleaded to call in proof of their petition. It is true that litigation, particularly election dispute litigation, is fought on pleadings. Parties swim or sink with their pleadings. For this, see the case of Anyafulu and others versus Meka and others. See also Ifeanyichukwu Osondu Company Limited and another versus Ahibe. Those pleadings in paragraphs 41 and 42 of the petition having been abandoned are discountenanced. In the same vein, paragraph 96 of the petition averred that agents of the second and third respondent disrupted the election. Votes scored were not accurately recorded and the ballot papers were torn. The petitioners averred that video recording shall be tendered. However, the video recording was not tendered in that regard. In this respect, the presumption in Section 167D of the Evidence Act 2011 that they withheld the said video recording because it will be against them if tendered shall also apply. From the foregoing, therefore, it is very clear and certain that the petitioners have failed to prove that the 2023 presidential election and return of the second respondent was invalidated by reason of corrupt practices or non-compliance with the Electoral Act 2022. This issue, that's issue 1, is therefore resolved in favor of the respondents and against the petitioners. Issue 2 is whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023. He having not secured one quarter of the total valid votes cast in the Federal Capital Territory, Abuja. This issue has been resolved in petition number 3, and we adopt our finding and conclusion in that regard in this petition. Page what? Issue 3 is whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended to contest the presidential election held on 26 February 2023, having regard to the alleged order of forfeiture arising from the drug-related offense, his acquisition of the citizenship of the country other than Nigeria, and presenting a forged certificate to the first respondent. I do not intend to reopen this issue, having already ruled on it while considering the preliminary objections of the respondents. I held therein that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and their efforts to remedy it through their replies to respondents' replies were belated and of no avail. That ruling constitutes issue estoppel, binding not only on the parties, but on this court, meaning that this court cannot depart from their earlier ruling. So this issue is therefore discountenanced. This issue is whether the second respondent was elected by majority of lawful votes cast in the, that's issue 4, yes. This issue is whether second respondent was elected by majority or lawful votes cast in the election, and first respondent was right in declaring him as elected. This issue covers ground 3 of the petition. The facts in support of this ground were pleaded by the petitioners from paragraphs 105 to 145 of the petition. The petitioners specifically pleaded in paragraph 106 to 107 as follows. The petitioners shall lead evidence at the hearing to show that A, the result of the election as announced by the first respondent, and especially the votes allocated to the second respondent, do not represent the lawful valid votes cast at the election. And B, the lawful votes cast at the election were deliberately and massively deducted from the first petitioner's scores by the first respondent in order to return the second respondent. 17. The petitioner shall give evidence to show the election results as purportedly declared by the first respondent in respect of each state of the federation, including the Federal Capital Territory, the details of which are contained in the table following are wrong. The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So where the complaint in an election petition is that candidate returned did not poll majority or highest votes in the election to be returned as contended herein by the petitioners, not only must the figures disputed be pleaded, the figures or votes the petitioner perceives as the correct figures of the election ought to be and must also be pleaded. That is not only logical. Support for it can be found in several decisions, among them Nadabo versus Dabai, where Okoro Jesse, as it then was said, when a petitioner is alleging that the respondent was not elected by majority of lawful votes, he ought to plead and prove the votes cast at the various polling unit stations, the votes illegally accredited to the winner, and the votes which ought to have been deducted from the supposed winner in order to see if it will affect the result of the election. Where this is not done, it will be difficult for the court to address the issue. See Awolo and Shagari, close of court. See also Ojo versus Isohe and others, Taba Jesse as it then was. The averments of petitioners in paragraph 107 of petition only showed the votes declared by ANEC, which the petitioners are disputing as manipulated. Nowhere in the petition did petitioners plead that what they considered the authentic votes of the election to guide the court in the inquiry suggested by them in this allegation. The second respondent did not poll majority of lawful votes in the election. Their petition therefore did not meet the legal threshold to ignite a proper inquiry by this court, and so lame even on the pleadings. Going further, if we must at all, the petition claim is that 19,702 polling units results contains various forms of infractions. They assert that results from a total of 4,307 polling units are without stamp on the respective forms EC8A from the states, and details are said to be in the statistician's report, which report we have repeatedly held incompetent and inadmissible. They also contended the results from 1,300 polling units do not have signatures of the presiding officers on the respective forms EC8A. It was also alleged that results from 6,408 polling units have and indicate zero accreditation. It was further alleged that 9,464 polling units across 30 states showed that the votes returned are in excess of accredited voters. Furthermore, that the presiding officers failed to properly fill and countersign alterations in election forms, including forms EC8A EC8B, EC8C, and EC8D in over 40,000 polling units, which they claimed were in the statistician's report. It is clear from the averments in the petition as captured above that neither the particulars of the polling units in issue nor those involved in the irregularities were given by the petitioners. In any case, our law is well settled that before a party can legally rely on fraud or forgery or any form of malpractice as alleged in this petition, the facts must not only be pleaded but particulars thereof must be provided in the pleadings. The petitioners in the pleadings from paragraphs 128 to 142 avert to issues of violence and disruptive activities. These allegations are criminal in nature. The standard of proof where an allegation of crime is made in an alleged petition is proved beyond reasonable doubt and not on the balance of probabilities. See Emmanuel and Umana. A complaint of massive suppression, deduction, and allocation of votes connotes forgery or fraud, particulars of which must be pleaded and proved beyond reasonable doubt. See Kaki and PDP and others, Ngobodo versus Ono. First, respondent joined issues with the petitioners' allegations in paragraphs 92 to 142 of the petition. The second respondent and the third respondents in a similar manner joined issues with the petitioners in calling on them to prove their claims as required by law. What this entails is that the petitioners who made all these allegations have the burden to prove all the allegations as required by law. The petitioners have placed reliance on the evidence of their statistician and forensic expert, who are PW21 and PW26 respectively. Had time to look at the evidence of these witnesses and had ruled that their evidence, apart from being improperly before the court, is also hearsay. The statistician's report rolled out figures or forms which he claimed were either not signed or stamped, but none of the forms referred to was attached to the report. The polling unit agents of the petitioners who were present in all the polling units around the country were not called to testify to any problem or difficulties in their polling units on the 25th day of February 2023 presidential election. That is fatal to the petitioner's case. Thus, in Belgore versus Ahmed, it was said by Taba JSC as followed in the lead judgment. With respect to the volume of documentary evidence, I wish to state at the risk of repetition that they were merely tendered across the bar by Land Council for the petitioners at the trial. He did not and was not in a position to answer questions or otherwise speak on any of them. Their makers were not called. In such circumstance, was the trial tribunal bound to ascribe probative value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord probative value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 2856 of the 1999 Constitution as amended. That, however, does not diminish the petitioner or appellant's burden and standard of proof of the petition. They had a duty to prove their petition according to law, close of court. This position of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be gainsaid that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, where the complaint verges on whether an alteration or amendment in an original or certified true copy of a polling unit result was made with intent to falsifying it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the documents in order to prove falsification or election documents when it is so alleged, as pointed out in Belgoled and Ahmed. See also the case of Waziri Ibrahim and Shagari. and Buhari versus Obasanjo. All the above, in my view, also explain the rationale for the employment of the adverb manifestly by the draftsman in section 137 of the Electoral Act 2022. What the word suggests is that the non-compliance complained of must be apparent on the face of the electoral document. It must not be something that can be explained away by oral evidence one way or the other. I have in this judgment explained the issues of evidence of witnesses who were not polling unit agents. The collection agents of the parties who testified were given accounts of stories related to them by people who were not called as witnesses in this petition. The interpretation of Section 137 of the Electoral Act 2022 by the petitioners was generously and swiftly silenced, the otherwise potent adverbial word manifestly used by the legislature in that section of the law. Manifestly is defined by online dictionary to mean in a way that can be readily seen by the eye or the understanding plainly or obviously, evidently close, of course. This means for the petitioners to throw up their arms and say we need not call oral evidence in proving non-compliance as they are conversing. The certified copies of documents presented must be manifestly and readily seen to convey the fact of non-compliance. We have started this Oetolo and Anik JSC. From this authority, it is the law that where the documents tendered and relied upon by the petitioners do not manifestly disclose the non-compliance alleged, the petitioners will still need to call witnesses who witness the alleged acts of non-compliance to testify. In the instant case, the petitioners tendered loads of certified copies of the document. The petitioners filed 5 schedules of documents. The first schedule was filed on 30th May 2023. The second was 31st May 2023. The third was 2nd June 2023. The fourth was 7th June 2023. And the fifth was filed on 21st June 2023. From these schedules of documents, a lot of exhibits were generated and tendered. These exhibits were objected to by the respondents. I had earlier in this judgment dealt with the documents and objections. However, I want to have a look at this document to see if they manifestly show any lack of compliance. These exhibits include the following: exhibits PG1 to PG3, which were the printouts of bimodal voter accreditation system, VIVAS, for Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ekiti, Enugu, FCT, Abuja, Gombe, Imo, Jigawa, Kaduna, Kano, Katsina, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Ondo, Oshun, Oyo, Plateau, Rivers, Sokoto, Taraba, Yobe, and Zamfara were admitted, though objected to. Exhibit PH1 to PH36, which were the earned data on number of registered voters and collected PVCs for the 2023 general elections for the states listed in the first schedule of documents as numbers 46 to 82 were admitted. The second schedule of documents was filed on 31st May 2023, and the documents listed here Surprisingly, the documents were dumped on the court without any witness linking them up with the specific complaints of non-compliance. It is certain law that despite the tendering of exhibits in proof of a petition, the onus of proving the case pleaded and for which the documents were tendered in evidence lies on the petitioner. In the instant petition, a lot of documents were tendered from the bar. when a party decides to rely on documents to prove his case, there must be a link between the documents and the specific areas of the petition. The party must relate each document to the specific case for which the documents were tendered. Failure to link the documents is fatal and catastrophic, as it is in this case. The Supreme Court, in the recent case of Tumbi Bido versus Anik, have cited the portions. In this situation, it is invariably correct that all the allegations raised in this petition have not been proved as required by our law. See Buhari and INEC, part 12 JSC. It is also important to draw our minds to the fact that criminal allegations are usually and directly made personal. For allegations of crime to be proved against the respondents, it must be proved that they committed the corrupt acts or aided, abetted, consented to, or procured their commission. Furthermore, it must be proved that the corrupt practices substantially affected the outcome of the election. See Omishore versus Aribeshola. The law also places the onus on the petitioners to demonstrate by credible evidence that the alleged corrupt practice indeed occurred and that it affected substantially the outcome of the election. In that quest, the petitioners pleaded some states where the malpractice allegedly occurred. One of such states is Sokoto State. They placed PW19, PW21, and PW22 to prove the allegations that the first respondent cancelled results from 241 polling units in Sokoto State in respect of National Assembly elections in the state, but went ahead to declare results for the presidential election. The three witnesses, PW19, 21, and 22, were not in Sokoto during the election. There is also no evidence tendered of the cancellation of results in any of the units alleged. PW19 and PW22, when cross-examined, said they were in Kogi State, where they voted, and later came to Abuja. The PW21 is the statistician who testified of overvoting, non-signing, and cancellation of forms used, but he did not tender or show those compromised forms. The same occurred in their testimonies in Kano State, Kogi State, Lagos State, and River State. From the foregoing consideration, it is very clear that there was no credible evidence by the petitioners to prove the allegations of corrupt practices. Under this issue raised, the petitioners were asking if the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of lawful votes cast in the election. From the facts placed before the court, the first respondent declared the results of the election by which the second respondent was returned. Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, four issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the three petitions, number CA from PEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-23 are all devoid of merit, the petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected president of the Federal Republic of Nigeria. The parties in the three petitions are to bear their respective costs. So now I will call on my learned brother by immediate right to reach his own judgment.
All right. People, I want you guys to refresh. We're gonna end this particular one and come back in the next 1 second. Refresh to follow us up. They've already declared Tinubu, right? We need to make a speech. Let me end this one. Join us right away. God bless you all.